Usual, we have to wait a quick second to make sure that the stream is fired up across the internet. This usually takes a quick second or two. YouTube is always a little bit slow, so let's give it a second, and it looks like we are live, so let's get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system, with the hope of encouraging some meaningful change. We're very grateful that you are here and with us today. We've got a lot of impeachment nonsense to talk about. It was one of the most boring days in terms of political news that I could imagine in recent memory. It was a lot of sort of the same things we've been talking about. This is supposed to be one of the biggest, most important, trials of our political lives because of what happened on January 6th. And it was not that. It was quite bland. We're going to go through it. We have the House rules and the Senate rules on what the trial is going to look like. Today was all about jurisdiction, so we're going to spend a little bit of time talking about that and some of those arguments. If you've been following us thus far, you've known we've been talking about some of this stuff for the last 2 weeks or so. So we want to break that down. We also want to get into some clips from Rep. Joe Neguse over from Colorado. We've got Jonathan Turley, another constitutional lawyer who responded. And then we're going to be diving into, after we get done with some of this impeachment stuff, it was a little bit boring, so we're not going to spend the whole show on it. I also want to get into this new little scandal that's brewing here in Phoenix. There's this thing going around, there was this thing going around called a challenge coin. People are calling it different things, but it's this challenge coin the Phoenix Police Department was spreading around, and it's turning into this little bit of a scandal. There's a reporter here from ABC 15 who goes by the name of Dave Biscoe, who's done an outstanding job investigating what this is, but it all stems from the protest that took place a couple years ago in 2017. So we want to bring you up to speed on this story because I think it's going to be pertinent for the foreseeable future. And then at the end of the show, we're going to dive in a little bit onto Ghislaine Maxwell, Jeffrey Epstein's number 2, because there was a new order that came out yesterday, 2 orders, in fact, that show that, some of her success in trying to keep her 2016 depositions under seal, those are flying out the window. For some period of time, the courts had said originally that they were going to keep that stuff secret because she's talking about some sex stuff, or who knows, we really don't know what she's talking about, but there was a big attempt from her attorneys to keep that secret, and now that is going to be coming out. So we've got a lot to get into today. Don't want to waste a lot of time. Want to remind you that if you want to be a part of the chat that we're going to have at the end of the program, please head over to locals.com to do that. Watchingthewatchers.locals.com is where we're going to chat at the end of the broadcast. And it's also where you can get a copy of the slides that I'm about to go through. So we're going to go through a lot of material here, look at some primary source documents, and then you can get those at the end of the show. Locals.com is a nice website. There's a lot of other creators over there, so go check that out. All right, so let's get into it. As I mentioned, I wanted to start with sort of a little bit of an overview on what this is looking like. And I put together a little bit of a diagram here just to give us a high-level overview, a little bit of an understanding on where we're at as it relates to the impeachment proceedings. Okay, so right now we are in a trial. The trial is taking place in the Senate. Donald Trump has already been impeached as a result of what took place in the House of Representatives back in January, right after the Capitol Hill riots took place. And so today we were only having conversations in the Senate about jurisdiction. Okay, that's it. That's all that the rules said. And I want to show you what the rules said specifically. This is the resolution, and this is saying that is Mr. Schumer and Mr. McConnell, they submitted their resolution, and this was to provide for related procedures concerning the article of impeachment for Donald Trump. And we're not going to go through this whole document, but I just wanted to show you what was scheduled for today. So today, Tuesday, February 9th, there shall be 4 hours of argument by the parties equally divided on the question of whether Donald Trump is subject to the jurisdiction of a court of impeachment for acts committed while president, notwithstanding the expiration of his term of office. So can he still be impeached? Can he still be tried even though he's not in office anymore? That's what we were trying to discuss today. Each side may determine the number of persons to present argument for the foregoing questions without any intervening action, except for deliberation. They're going to go and move forward. They're going to be able to vote. Basically, it's going to just be a quorum. If it's a majority vote, then they can move forward. And it's going to say they're going to decide by yeas and nays. If they vote in the negative, meaning if they vote that there's nothing constitutional about this, they're going to dismiss the case. And if it is approved, then it is going to move forward. And we already know, if you have been following the news, it's been approved. I think it was 56 to 40 something. I'm going to show you that slide here in a minute. But those are the rules. We're just talking about jurisdiction. So what I did is I put together a little bit of a flow chart on, for example, how I would be handling this case if I were a prosecutor. If this were a real court of law, if we could talk about, some civil law elements, some criminal law elements, some political elements, if we could cram all of that into one proceeding, which is kind of what this is in the impeachment proceeding that took place today, this is how I would do it. Now, if you've been a regular of the channel, you know that largely I've been pretty sympathetic to Donald Trump's defense here, because I just don't think that his conduct on January 6th or even preceding that it amounted to insurrection, that it was an incitement of insurrection. I've said that it's reckless. I said that I don't necessarily agree with a lot of what he has said out there or how he framed it or phrased it, but is it criminal? Is it a high crime or misdemeanor? Is it something that warrants impeachment? I just haven't seen legally how that works, how you can get there. And I'm a criminal defense attorney, so I like to take hard cases. I like to defend people. That's just my instinct. I don't like the government prosecuting anybody, whether it's a single mom who is being charged with a license plate violation, or whether it is somebody who is the former president of the United States. I want the government to prove their cases. They don't just get to say something bad happened and we're angry about it, so we got to charge somebody with a crime. They got to prove it, and they got to go through the motions in order to do that. And I just have not seen that here for the impeachment proceedings. And I know a lot of people disagree with me, but if I were a prosecutor, this is what I would do. And let me show you this flow chart. It's not something that is the only way to do it. It's not something that is the right way or the wrong way. It's just one way to do it. And I'm using this for illustration, for illustrative purposes only. Feel free to disagree with it. Here is what the flow chart looks like. And so what I want to do is run you through this. This is generally how, loosely how a criminal case would work, or how an impeachment proceeding, in my opinion, should work. That's not what we saw at all today. So let's run through this. We're going to start up top here. What you need, of course, is a bad event, right? Over here, this first box, this is going to be a bad event. And it's going to be, of course, the Capitol Hill protests, or you could really define this however you want. Put whatever you want in there. The riots, you could call it Trump's speech, whatever it is. Then you're going to need to establish jurisdiction. So the court has to be able to hear the case, right? If you get charged with a DUI in the state of Texas, Texas has to hear the case. You can't go to California because California doesn't have jurisdiction over the underlying charge. Courts have different jurisdictions, right? You don't file a DUI case in the United States Supreme Court. They don't have any jurisdiction over it, right? Unless there's an appealable issue and they grant a writ of certiorari and all that stuff. But largely that happens at a lower level state court. So we were just talking about jurisdiction today, and specifically about whether the Constitution permits this to move forward, whether the article of impeachment was severable, whether there were any procedural problems that the Republicans could use to throw some of this stuff out, and so on. And this is where we were supposed to just hang out. We were supposed to spend a lot of time only talking about jurisdiction, because this is a threshold issue. You can't move forward. You can't talk about incitement or insurrection or interference or anything unless the court has jurisdiction. And we know that they do have jurisdiction. They just voted that way. So we know that we're moving forward tomorrow into this other stuff. But today was only supposed to be about the jurisdiction. Now, what you'll notice is we didn't really spend much time talking about that, at least from some of the commentary that we heard from some of the Democrats today. I heard Raskin, the U.S. House representative, the impeachment manager, talk a lot about how much harm there was. I think we had a 17-minute video or something of all the damage that was occurring around the Capitol building. all the harm. Raskin gave this very emotional plea where he was specifically saying, we just buried my son. You know, my daughter was there at the Capitol and we were scared to death. I heard pounding on the door. It's a very emotional statement, and I have a lot of empathy for the man. He sounds very, very fearful. His daughter was very fearful, and it's not something that I would want anybody in this country to experience. But that's just that, right? What does that have to do with anything else here? What does that have to do with incitement, causation, insurrection, or any of these other things? Basically, what he was talking about was not jurisdiction. He was talking about the interference. He was saying there was a lot of interference. There was a lot of problems going on that he recounted with his daughter and all of that stuff, but he kind of skipped over these other boxes, which again, I'm going to run through here briefly. So we spent a lot of time talking about sort of the verdict that Donald Trump should be guilty because of there was interference. And we kind of skipped over things like causation, whether there was actually insurrection taking place or whether there was incitement. And so I understand what's happening here. Okay, I understand that this is a political spectacle, that both sides are trying to just make frothy emotional appeals. Largely, the Democrats did that today. They want to rile you up. They want to bring out sort of the worst emotional experiences that they had so that you feel it, so that you also will associate those bad feelings with Donald Trump. And this happens a lot in criminal law, and it's not particularly ethical, in my opinion. What happens all the time is if the prosecution in a criminal trial has a bad case, let's say they've got a murder defendant, somebody's on trial for murder, the prosecution, they can't really prove that he did it, but they have a lot of victims, right? They have a dead guy, they have his wife, daughter, spouse, husband, brother, sisters, employers, everybody, and they just parade them into court. And it's sympathy statement after sympathy statement. Your Honor, don't do this, right? It's in the course of trial. And they're just parading all of these people in front of the court. And you as a defendant, you're going, okay, well, that's great. We're sorry for your loss. We're sorry that he's not around anymore. I'm very, regretful that he's not here. And it sounds like, Mom, you're hurting. Dad, you too. Brother, you too. Sister, witness, all these other people who know that this person is dead and their lives are over because of it. We get it. Right? Awful situation. But what does that have to do with anything connecting my client to that death? They still got to prove that he was there, that he caused it, that he didn't cause it out of self-defense, that there was no other supervening cause or intervening cause. Or there's a lot of other things that they have to prove. You can't just bring in a bunch of people that have been harmed by something and just sort of loosely tie that to the original charge. I know it might feel like that's okay. You might be able to say, well, this is really traumatic. I mean, this is the Capitol building. Oh my goodness. This is a threat to America because of what we saw happen there. Yeah, it was egregious. It was gross, but did Donald Trump cause that? Did his speech incite it? That's what they got to prove, and they skipped most of that today. They just kind of jumped right into it. We do have a clip from Joe over from Colorado, a representative who talked a little bit about it and mentioned Jonathan Turley, and we're going to get into all of it. But we just want to be very clear about where we're at in this process, because you have to go through formal due process. Typically, this isn't a regular criminal trial, but it should resemble a criminal trial. It should resemble some sort of due process that you would see in a regular court of law, because Donald Trump is on trial for committing high crimes and misdemeanors, one of which happens to be the incitement of insurrection. All right, so let me run you through how I would break this down if I were a prosecutor. Okay, now, if I am the prosecutor, of course, we're going to get past the jurisdictional hurdle. We have to show that it's constitutional, that there is no severability issues, and that procedurally it's all okay. Right? And they basically did that today. So we don't have to spend a lot of time on that. But once you get there, then you also have to prove incitement. Okay? And incitement means something. It's not just that you said some bad words. It's about you knowingly said something that was intended to do something, and then something happened, right? And there's some standards that we've talked about. So if you're a prosecutor, you got to identify it. What's the language? What did he say? And what was the resulting cause? What happened? Like, what was the harm that came as a result of that? And so that's incitement. Now, they tried to do that in their article of impeachment in a 4-page document that was largely a joke. We've made a joke about it. We talked about the impeachment party. I wrote templates to show you how easy it is to just fill in that basically blank form and impeach anybody you want for incitement. It's a very low standard that they set because they referenced 2 statements in that article from Trump's speech. That's it, just 2 quotes. And they were both very benign if you read them in context, which we did on this show. So very, very benign stuff. They went forward on it anyways. Then when they realized that the underlying article was so sort of facially deficient, they beefed it up with an 80-plus page memorandum that sort of brought in a lot of other stuff. They expanded the scope of the inquiry. Now they're talking about, well, just not those two statements in Donald Trump's speech, but they're also talking about what Rudy said and what Don Jr. said and what Sidney Powell said and what Lynn Wood said. And you go, wait a minute, I thought Donald Trump incited this. Now you're saying that everybody else is responsible for it. All right, so they're modifying their argument a little bit. But you also have to consider what some of the defenses are. So let's break this down again. You have to have incitement of something, okay? Incitement by itself is something that leads to some other action. Yesterday, we talked about the Brandenburg test. And on this flow chart, in red, these are the defenses. So if you're Donald Trump's defense teams, you would bring this up in response to this. So if the prosecutor is saying, okay, we have enough here to prove incitement, Donald Trump and his team could just simply respond and they could say, well, that actually doesn't fall within incitement because the U.S. Supreme Court has said that you can follow the Brandenburg test, which says you have to be likely to incite something, and it did incite, and you're using the reasonable person standard. If that all is okay, if that all happens, then this Brandenburg defense will fail. But if it doesn't meet all of those elements, then this is an absolute defense to the incitement charge, right? There is no incitement, therefore there's no insurrection, and the whole thing goes away, right? And so Donald Trump would use the Brandenburg defense, and I didn't hear any of that today, which we shouldn't because we're still talking about jurisdiction. But are we going to hear that tomorrow and Thursday? I don't know. So once again, incitement. What are you inciting? We went through some of the Brandenburg stuff yesterday. The U.S. Supreme Court, when we were talking about the KKK member who was out there saying, we're going to take to the streets, and he made some veiled threats. They said that's not enough. Okay, that's not incitement. You want people in this country to be able to get out there and speak vocally. The Supreme Court has even said things like, if you go on Cornell's website and look up the Brandenburg test, then you'll see what it says. And it will tell you very clearly that the Supreme Court favors the side of free speech, especially political speech. If you're out there being vocal, that's political speech. That's protected, especially if it's in the context of an election, which is exactly, what Donald Trump was doing. So the Brandenburg test is a defense. Now, incitement can be other things, right? In this claim, they're talking about the incitement of an insurrection. But you could also incite other things. You could incite a riot, right? You could incite a murder. You could incite, manslaughter. You could incite, public disorder by screaming fire in a crowded theater. You can incite a lot of things, but you got to incite something else. So the first thing that they would have to do is say, well, Donald Trump, he was responsible for the incitement, but what did he incite? And that's where, as a prosecutor, you'd come back and you'd say, well, it was pretty clear, right? It was an insurrection. And we defined insurrection on this show. And I actually I kind of adopted the looser definition of that, where I think arguably you could make the claim that what happened was an insurrection. Very brief. It was like 3 hours maybe. But yeah, they were interfering with the government operation. They were interfering with the counting of the electoral votes, and that was a big problem, right? That's insurrection. So Donald Trump incited the insurrection, just like you could incite a riot. This was insurrection because it involved the U.S. government. If he was inciting a riot at a Walmart, well, then this element doesn't get met, right? Because there's no insurrection there. It has to be interfering with the government. And so as a prosecutor, what would you do? You'd say, well, Donald Trump had the mens rea. He had the mental state. He had a guilty mental state. He wanted this to happen. He was intending for the electoral vote count to be disturbed. And I think you could make an argument for that, which they're probably going to do tomorrow. You could go back all of his prior statements and say, yeah, kind of a pattern here. Right now, that is not in the article of impeachment, so it's sort of after the fact they expanded the scope of this thing. But you could make that claim. I don't think that he intended there at all. Personally, I don't think that you can glean from his speech that he was intending that the Capitol building be stormed. But I can see the argument. And then you have to have what's called an actus reus, which is a physical act. Right? This is an act in furtherance of the offense. So you got a guilty mind and you've got a guilty act. So not only are you thinking about a crime, but you're also moving the ball forward to commit the crime. And so if they can prove that, and they would say, well, his speech that directly came from incitement is enough. Right? And that's how they would define that term. And so they would say, okay, we have jurisdiction. We also have incitement because it fails a Brandenburg test. And They interfered with the government, so now that's going to be an insurrection, right? Now, Donald Trump, his automatic defense is going to be, that's political speech. I'm allowed to say it. Okay, I'm allowed to get out there and talk about this stuff. And I think he's right. If the Supreme Court, if you read some of their case law on First Amendment, especially political speech, it's highly protected. Highly, highly protected. It's basically one of the main reasons we have free speech, so that you can be vocal and even volatile about politics. Now, you may disagree with it politically, but if you have a problem with an election, if you think that an election was fraudulently conducted, don't you want to be able to speak out about that? Don't you have to be able to speak out about it? And how do you do that in a way that isn't volatile? Okay, Trump is a show person. There's no question about it. I think he could have easily tampered down his language. He could have said, well, I think that this was an election that was not legitimate because of the irregularities that I saw. But he doesn't talk like that. He says this thing was stolen. They ripped it out from under us. That's political speech. It's not well advised in hindsight in 2020, but is it not protected? I think that it is. And I think the Supreme Court would agree with that. So here you've got Donald Trump raising a defense of political speech. Insurrection, political speech. That's his defense. Now, if the Democrats can overcome that, which they have tried to do, they've said that, well, it's not protected under the First Amendment. We can still move forward with an impeachment, which they're going to continue to do. Then they can just say, well, this defense doesn't count either. Okay, so now they have to move on. They got to show causation. So not only does the court have jurisdiction, not only did Donald Trump say something that led to something else called insurrection, but all of that was the cause of the interference. Okay, because if you have incitement, but somebody else caused the ultimate interference, well, then that's a not guilty for Donald Trump. So causation means that they can tie this incitement directly to the interference. So there's a breach of conduct here that was directly caused by Donald Trump that resulted in the governmental interference. Donald Trump's defense would be, I didn't cause that. And I wrote down here intervening or superseding causes. Donald Trump can say, no, I was giving a speech. Something else set them off. Something else released them. I was speaking. They were walking towards the Capitol before I was even done with my speech. Something was intervening, some external cause, or an entirely different cause, right? It could have been Q. It could have been, it could have been any other politician. It could have been third parties that are organizing militias around the country that were just upset that Joe Biden won. Just in general, right? I mean, there's a million different people or different organizations that, well, not a million, but you get my point. There's a lot of other organizations that are highly involved in this. Okay, we've had the Oath Keepers, you had the Proud Boys, we've had BLM people who were there, and on and on and on. So was anybody else the underlying cause? Did somebody else step in? What else triggered it? That would be Donald Trump's defense. I didn't cause it. It happened. Yeah, it was really bad. It happened, but I didn't do it. People were upset. CNN, MSNBC, Fox News, anybody else, right? That would be their defense. Then you'll also run into interference. Now they got to show that. What was the interference here? Pretty clear, pretty obvious. This is easy to prove. This one is not even, I don't know, you can't even argue with this. There was 100% interference. Congress could not count the votes. They got interrupted for 3 or 4 hours. They were back. They finished it. But there was interference. Now, I wrote also negligence. Negligence is sort of a causation argument here, but I also wanted to sort of bring this up. Negligence. So if Donald Trump says, if they say, no, there was absolute interference here. Capitol building was stormed. Huge mess. Not so good. Trump can come back and say, well, you contributed to that, government. You were the one responsible for it. Mayor Bowser refused my help. We were going to send in, I saw a headline today, 10,000 additional National Guard. That was declined. The Sergeant of Arms in the House and the Senate, they were on notice, according to the former chief of police for the Capitol Hill Police, that this was going to be a problem. They declined because of optics. The government that's responsible for making sure that the Capitol building is safe and secure, they were negligent. That goes back to causation. Donald Trump didn't cause it. If they prove that he did cause it, or they make the argument that he is, and that led to the interference, he responds back. He says, no, if the government had been prepared, if they were not negligent, then the interference would not have happened. Okay, it's just sort of like a superseding cause. This is the bigger cause, not Trump. Negligence was responsible for what we saw happen on January 6th, not the speech. The government was just not prepared. So it's another defense. Now, again, we didn't talk about any of that stuff. Now, if the Democrats can prove all this, if they can follow all the way through the chain and they can convince some senators, some Republican senators, that this is really accurate and it is egregious, then the Republican senators should vote to convict him. But they won't, because they're not going to go through this motion. Today, we talked a lot about this. We talked a lot about interference. And we actually really didn't even talk about interference, honestly. They were more talking about something down here that we would just call harm. Okay, which was harm. There was a lot. There was a whole different box, a whole harm box. And they were really going from this bad event that happened, a different box over here. So bad was up here. They kind of, tiptoed around jurisdiction, but they were just going directly around here. They were just saying, oh, something bad happened. There's a lot of harm that's taking place, that took place, and Donald Trump's responsible for it, so we're going to impeach the guy. Now, tomorrow we'll see if they are able to connect any of these other dots. I would have preferred that we spent some more time today talking and fleshing out some of these issues, but it was a disappointing day from both sides, honestly. Raskin was talking about a lot of emotional stuff, a lot of frothy appeals to emotion, a lot of video montages of stuff getting blown up and buildings getting demolished, and all of that stuff. Got it. We got it. There was harm. But that's not what we're talking about today. We're talking about jurisdiction, and then tomorrow we're expecting them to connect the dots. And it doesn't have to be this way. Many other ways that you can go about this, but you want to see some due process. You want to see that chain connected. Now, our first clip, we only have two. I've got one from the Democrats, and we've got one from the Republicans. Largely, this was an uninteresting day, in my opinion. I'm a real lawyer, actually, and this was like brutal to watch for me. I was flipping through it when Trump's first attorney came on, Castor. I was like pulling my hair out. I have no idea what he was talking about for 45 minutes. I had to turn it off. What is he talking about? And I think that it was probably a strategic thing to just waste time at that point. I really can't explain it any way else, but that was kind of the tone for the entirety of the day. Just kind of like, what are these people doing? Not even interesting, not even good arguments, just a disappointment across the board. We do have some semblance of a substantive argument from this guy. His name is Joe Neguse, I think is how you say it, over from Colorado. Let's listen in on what he had to say on the Senate floor today.
That I know some of you know, and some of you have actually spoken with recently. Up until just a few weeks ago, he was a recognized champion of the view that the Constitution authorizes the impeachment of former officials, and that is Professor Jonathan Turley. Let me show you what I mean. These are his words. First, in a very detailed study, thorough study, he explained that, quote, the resignation from office does not prevent trial on articles of impeachment. That's Professor Turley's words. Same piece. He celebrated the Belknap trial. He described it as a corrective measure that helped the system regain legitimacy. He wrote another article. He's written several on this topic. This one is actually, it's a 146-page study, very detailed. And in that study, he said, quote, that the decision in Belknap was correct in its view that impeachment historically had extended to former officials, such as Warren Hastings, who you heard Lead Manager Raskin describe. In fact, as you can see, Professor Turley argued that the House could have impeached and the Senate could have tried Richard Nixon after he resigned. His quote on this, very telling, quote, "Future presidents could not assume that mere resignation would avoid a trial of their conduct in the United States Senate." Finally, last quote from Professor Turley, that no man in no circumstance can escape the account which he owes to the laws of his country. Not my words, not Lead Manager Raskin's words, Professor Jonathan Turley's words. I agree with him because he's exactly right.
All right, well, he doesn't really agree with you. So Jonathan Turley is somebody that he kind of does agree with him, but it's a little bit more complicated than those little quotes that he pulled out of context there. And Jonathan Turley responded on Twitter. Jonathan Turley is somebody that we follow. I've talked about him and some of his scholarship on the impeachment articles. Brilliant guy, writes a ton, very familiar with the history of the country, especially as it comes to political issues. And so he posted right on Twitter, as soon as Rep. Joe Neguse said that on the floor, he said, well, Rep. Neguse just cited my Duke piece and said that I was an advocate until just a couple weeks ago for retroactive trials. I appreciate the citations, but it is not true. That article was 21 years ago. He says the issue on such close questions remains your default on such questions. I have certainly become more textual in the last 3 decades, which I have written about over the years. However, this was not a recent change as suggested by Joe. Neguse just used a quote that from Blount that is highly contested. First, as I have discussed, there was the question of whether a legislative official could be tried for impeachment. However, Neguse is citing Blount's line that he would never argue that a person can avoid accountability by resigning. Joseph Story and others did not believe that a former official could be held accountable in an impeachment trial. They did not rule out other accountability. So basically what he's saying here is, yes, he said that. He did say that 21 years ago, and it's still relevant. He actually still agrees with it, but he's adding some more meat around the bones. Back then, he was sort of talking about this in the context of, well, impeachment can be useful in those other situations where there are no other remedies that are available. When you don't have a Justice Department who can go and criminally charge a president or a former senator or whomever is being impeached. And so, amazingly, Jonathan Turley already wrote a response based on what he heard today on the Senate floor. And here is what he says. My recent position of 21 years ago, House Democrats cite a 1992 Duke article in support of impeachment. He said, recently I wrote about how Lawrence Tribe bizarrely claimed that not long ago I argued in favor of retroactive trials. Now House managers have claims that I supported those up to a few weeks ago. Rep. Joe Neguse cited my Duke piece at length to support the basis for retroactive trials after saying that I supported such trials until a few weeks. I felt he did an excellent job in his argument, but that statement is simply not true. His reliance, however, on the Duke article is not misplaced. I did and continue to recognize the value of such trials, and certainly the historical use of such trials. It is only his characterization of my position that was misleading. Indeed, if my views of 21 years ago are going to be cited as recent, please use my photo from the 90s. I was thinner then. To give you an idea of how recent this was, here's a picture of when I wrote it, right? So that's him. So he's kind of having fun with this. He's being very deferential. He's being very... he's being a gentleman about it. Indeed, as scholars, we are ideally always evolving our knowledge and our views. However, I still believe the retroactive active trials question, that they have dialogic value, and this remains a closed question. My default today is more textualist on the question. And so he's not really getting to this, but if you click that link, it will take you to this article. And he says the case against retroactive impeachment trials, a response to the open letter of the scholars. A lot of other people endorsed the constitutional basis for trying President Trump, but the letter contains many individuals I know and respect. However, people of good faith can disagree, and I would like to respond and offer a countervailing view. So I'm not going to go through this entire article. He wrote it on January 29th. You can go check that out. It's a good one, and I actually agree with it. If we go back to the original article, so this one where he was responding to what happened today, he said, while only briefly addressed in my past writings, my view of this threshold issue has continued to evolve over the last 30 years. I found over these decades that departures from language of the Constitution have produced greater dangers and costs. I've become more textualist in that sense, but I'm neither an originalist nor a strict textualist. I have discussed the trend in my writings over the last 3 years. If I were to write this piece today, I would still maintain that it shows how impeachment trials serve this dialogic role, but that of the 3 outlying cases, I agree with the decision in Blount and roughly half the Senate in Belknap, that such trials are extra constitutional. So he's saying, back then, these had value. It was good to talk about these things, but they were not constitutional back then. It was historically allowed, but I believe that it is not constitutionally sound. That view against retroactive impeachments is strengthened by what we have witnessed in the 2 Trump impeachment. Thus, I don't fault reliance of the Duke piece by House managers to support how they value retroactive trials and the historical defense of such trials. I still believe that. However, my textual views did not recently change. They have changed almost 3 decades. I've been criticized for my greater reliance on the text in such interpretation. So you understand what Joe Neguse was trying to do, right? He was trying to pick sort of this right-wing constitutional lawyer, cite one of his articles, and then make the claim, hey, look, even your own guy agrees that this thing's constitutional. So why don't you? And it's a good argument. It's a little bit disingenuous, but he may not have known the nuances of this, right? He was probably, him and his researchers were just looking for, they were looking for what they wanted. They found it and they used it. Now, Jonathan Turley just got on Twitter and said, no, that's not exactly right. I still don't think retroactive trials are constitutional. I did say 21 years ago that there was some value to them for having conversations about it back during that other era, but not so much anymore, right? So that was his point, counterpoint. Then we're going to get over to Donald Trump's attorney. So as I mentioned, his first attorney, I don't know what the heck he was doing. He was out there. He was like talking for 45 minutes and I could not even follow him. To me, it sounded like he was stalling. I think his defense team, as we read in the rules, they both got 2 hours to have a conversation. And I think they just split it right down the middle. David Schoen is the second attorney who came out. And he actually also had some legal arguments, which are good. That's what we wanted to focus on. But the first attorney, Castor, I don't know. Like I said, I don't know what he was talking about. About senators being good people, on and on and on. So we're just going to skip right over that. Here is David Schoen. So this is Trump's second attorney. This guy, people, I think were making fun of him on Twitter because when he was drinking a sip of water, he was covering his head when he was drinking it. He's going back like that. People are like, well, what does he have, a hole in his head? Is the water going to come out back? What's going on? Well, he's got a yarmulke, right? I think that's the thing. He's got a yarmulke on his head, or he's used to having a yarmulke on his head, and so he just typically will do that when he drinks, just because it's there. Want your yarmulke to fall off. So everybody on both sides today is just waiting for anything that they can grasp on, and it's kind of embarrassing. But all right, so that's that. Here is David Schoen today, and he's talking about something called a stipulation, which I'm going to explain.
They want to put you through a 16-hour presentation over 2 days, focusing on this as if it were some sort of blood sport. And to what end? For healing? For unity? For accountability? Not for any of those. For surely there are much better ways to achieve each. It is again for pure, raw, misguided partisanship that makes them believe playing to our worst instincts somehow is good. They don't need to show you movies to show you that the riot happened here. We will stipulate that it happened, and you know all about it. This is a process fueled irresponsibly by base hatred by these House managers and those who gave them their charge, and they are willing to sacrifice our national character to advance their hatred and their fear that one day they might not be the party in power. They have a very different view of democracy and freedom from Justice Jackson.
All right, so what he's talking about there is what's called a stipulation. And this is something that happens a lot in criminal law. Stipulation basically means that both sides are agreeing to something. And the example that I was thinking of is in a DUI case. And this is something that sneaky prosecutors can do, especially if you are a new criminal defense attorney. Be cognizant of this. If you're a defense attorney, be cognizant of this. If you're a prosecutor, don't do this. It's not cool. You're going to anyways, though. This happens. Let's say you're in a DUI trial. You're representing a client, and your client is let's say a college student, female, who gets emotional okay, when she gets stopped by the police. All right. So she's pulled over for allegedly drinking and driving. Now you've gone through the case, you've been working on it for months, and you're on the day of trial. You go to trial and you're having your arguments in front of the judge. You do your opening arguments, and the prosecution is presenting their case. And one of the elements that they have to prove, of course, they got to show that your client was, driving a car, right? And whether actual physical control or whether the car is in motion, you got to be driving. You got to get, if you're going to get a DUI, you got to be driving the car. You also got to be under the influence of something. You got to be impaired to the slightest degree. Your blood alcohol content has to be over the legal limit. There are certain elements, depending on your state, that they got to meet. But they also got to prove to the court that the person who was driving the car was in fact your client, right? Identification. They got to make that connection. And it may seem so obvious to you. You may just go, well, if she's sitting in court and, she knows she got the ticket and we're all there. Okay, fine. But it can get a little bit more complicated than that. They have to prove that it is your client. And so what often happens is the parties will stipulate to identification. Okay, so the government will say, well, and officer, isn't it true that the person you stopped and cited is sitting right there in court? And the officer will look at him and go, yep, that's her. That's who I stopped 6 months ago. Okay, that's one way that they can prove identification. Sometimes that happens. That's not sneaky. What some prosecutors will do is they'll say, okay, thank you, officer. And I also want to show you this picture. And I know you've identified them, but I want to show you this picture that we took, or that you took, right there on the side of the road. Okay, just to make sure that it's the same person. And what they'll do is they'll show that photograph to the officer. They'll show it to the defense. If you don't catch this, you could object to that photograph, and I'm going to tell you why in a minute. You could object to that, and you could say, nope, we don't need that, Your Honor. We're going to stipulate to ID. We're going to just agree that we don't need the jury to see that photo. We don't need that admitted as an exhibit. We agree that what the officer just said about our client is accurate. The reason why they want to get that photograph in is because your very emotional 22-year-old college student, guy or girl, whatever, it doesn't matter, right? If they're very emotional, they're going to be crying on the side. They're going to have mascara falling down their face. Their eyes are going to be swollen and puffy and bloodshot, whether they're drunk or not, right? If you're driving and you're pulled over and you're hysterical on the side of the road, you're going to look drunk in a photograph. You're going to look terrible. And the prosecutor wants to get that in order to make your client look bad. It's evidence, right? We're going to mark this as an exhibit. Just to show, officer, right, that's her. And so they're going to try to get it in on an identification basis. And unless you object to that, that document might come in and sit in front of the jury. And it's only for identity. But if you are a criminal defense attorney, you object to that. You say, Judge, look, we're going to stipulate to that. We're going to agree. We don't even need to fight over it. We acknowledge that identity is proven. Okay, both sides agree. You don't have to fight over that stuff. That's what would be good. Now, if a prosecutor gets that in, now a jury that was originally looking at your client sitting there, with nice makeup, nice clothes, ready for a trial, looking presentable, they look at her and they go, yeah, she looks drunk. She looks bad. She looks like a hysterical mess. We're going to punish her. And a defense argument would be, no, Your Honor, that provides no value to the determination about the person's identity. We already agree it's her. The jury seeing that photograph would just be way more prejudicial against our client than it would be probative. It's not going to add any value. It's just going to do more harm, right? And so the judge, typically, depending on the judge, will say, yeah, nice try, prosecutor, good job, but we're just going to we're going to just accept that stipulation and everything's going to move forward without that photograph being admitted. So it's a stipulation. It's the same thing that David Schoen was just talking about. And to go back to our flow chart, he is saying, yes, listen, we're going to stipulate to all of this. We're going to stipulate that there was massive amounts of interference. We get it. We'll even stipulate that they stormed the Capitol. All of this was harmful. Okay, we will agree with you 100%. They were breaking things. They were trying to steal the podium. They had their feet on Nancy Pelosi's desk. We got it. Okay, we'll agree to all this. We don't need videos. We don't need photographs. We don't need long, sort of winded statements about how traumatic this was for you. We all got it. We don't need that submitted as evidence. What we do need is to show all of these other chain links were connected. And we haven't gotten there yet. We have a couple more days. We'll see if we do. And so he's just basically saying, enough already, right? They were only talking about jurisdiction, or supposed to be, and it really didn't turn into that. So as we know, this is what the final vote count looked like. As to the question of whether former President Donald Trump is subject to the jurisdiction of a court of impeachment for acts committed while president, everybody voted, 56 voted yes, 44 voted nay. Who voted yes of the Republicans? Well, got 6 of them, and it's, as I have been calling them lovingly, the squishy Republicans, the ones who are always sort of in the middle. We've got Susan Collins from Maine, Lisa Murkowski from Alaska, Mitt Romney from Utah. We got Cassidy over from Louisiana, Toomey from Pennsylvania, and Sass from Nebraska, who I think will probably be running for president in 2024. And then what do the rules say about tomorrow? Before we change gears, the former president in the House of Representatives shall have until 9 a.m. on Wednesday to file any motions permitted under the rules of impeachment, with the exception of motions to subpoena witnesses. So no witnesses are coming in tomorrow, or documents or any other evidentiary motions. So I'm not sure what they're going to be filing, but they're filing stuff as long as it's not subpoena witnesses or documents or any other evidentiary motions. Responses to any such motions shall be filed no later than 11 a.m. tomorrow on Wednesday. And then all materials filed pursuant to this section are going to be filed with the secretary, printed, and made available to all parties. Arguments on the motions will begin at 12 noon tomorrow, and each side may determine the number of persons to make its presentation, following which the Senate shall deliberate, if so ordered, under the rules of impeachment, and vote on any such motion. So tomorrow morning, we're going to see a lot of activity. They're going to be, drafting motions, presumably. Everything needs to be submitted early tomorrow. Our response is then due by 11, and then everything in terms of arguments will start at 12 p.m. for another day of the impeachment spectacle. All right, so let's change gears. Let's leave some of the impeachment stuff behind, because there's some other interesting stuff, even more interesting stuff going on. I want to tell you about this Phoenix Police Department story. There is kind of a scandal brewing here in Arizona. This article was put together by a guy here who's an ABC 15 staff reporter. His name is Dave Biscobing. Huge fan of this guy, huge fan. I would tell you to go follow him at Dave Biscobing 15 on Twitter, because he is just a grinder on the police here in Arizona. He just goes after them very hard, and we have a lot of respect for him for doing that. Kind of the whole weight of ABC 15 and all of their reporting, and with him leading the charge, they have put together some outstanding reports that we have covered here. I think I played a large part of one of them a couple months ago. So he has this new article. It says, Phoenix City Manager, the PD chief, call for an investigation after his report, the ABC 15 report, on a protest shooting trophy. What? The police have protest shooting trophies? Are you kidding me? No, I'm not kidding you, in fact. Phoenix's city manager and chief of police are calling for an outside investigation after an ABC 15 report exposed a commemorative coin shared and sold between a team of officers to celebrate shooting a protester in the groin in 2017. Okay, so literally they're trading coins. The challenge coins clearly depict the man being shot on the front and have the date of the protest on the back. The coins also have the following 2 phrases: "Good night, left nut." "Make America great again, one nut at a time." Police in Phoenix, folks. All right. Here is Dave Biscobing. Police shoot, then celebrate. Our latest ABC 15 investigation shows Phoenix police officers kept trophy to commemorate shooting a man in the groin during a protest. And here is the coin. Good night, left nut. And they have this guy getting hit in the nuts. Okay. We saw this in the news. Making America great again, one nut at a time. Phoenix AZ, August 22, 2017. I laugh, but this is disgusting behavior, right? I mean, this is the police celebrating shooting a guy in the groin and like having coins made and then transferring the coins from one person to another. Oh my goodness. All right. Phoenix Police Department trophy celebrates shooting a man in the groin. We have the video. Protest occurred August 22nd, 2017. Following President Trump's visit to the Phoenix Convention Center, things got tense. Phoenix police shot pepper balls at the feet of a crowd while some people threw objects and gas canisters back at the officers. It sounds like If they're throwing things, that sounds like that might be insurrection or like an incitement of insurrection. I'm not sure. In all of the chaos, the shooting of Joshua Coben became the iconic and lasting memory of the night. Video captured by the Phoenix station KTVK shows Coben kicking a gas canister away from the police. Seconds later, he's shot in the groin with what's called a pepper ball. Here it is.
That line of officers in defiance.
You just saw one of the protesters go up there and actually kick a can of that.
Out here that are kicking the pepper spray back, and a guy just got shot with a rubber bullet.
The video.
All right, so that's that. Right, he's okay. Hopefully his, his manhood is still intact. I'm sure that it is. I'm sure he's okay. Hopefully, I don't know. I haven't read the rest of the article just yet. Miss Faith clipped most of this today, but that's not the point, right? The point here is that the Phoenix police are sort of getting off on this. They're literally transferring coins from one person to another. Let's take a look at where this article goes. It says, no discipline. The coins were largely kept and shared by the Tactical Response Unit. As part of an ongoing class action lawsuit against the department for their protest response, Chief Jerry Williams and several members of the special unit were deposed. Right now, there's ongoing lawsuits because of the protests. People have been arrested and they're charged with crimes for just protesting, which of course is protected political speech, in my opinion. Williams' deposition took place August 2019. The chief was asked several questions about the coin, whether it would be appropriate for her officers to create or have an image like that, and she said no. But apparently no officers were investigated or disciplined related to the coin, according to an email sent to attorneys seeking records in 2020. Of course not. Why would they investigate them, folks? They're the police. They don't do anything wrong. In response to a request from any documents and actions related to the coin, they responded by saying there are none. There are none. No documents or actions. There are no records because the coin was not department-sponsored or funded coin. It's their personal coins, folks, that they were celebrating their performance of their duties. It's just like they should be congratulated for that, right? Dave says, any check on this statement from the Phoenix police, quote, any such coin, it exists. The PD knows it exists. The chief was shown it during a deposition. Officers testified that they owned, shared, and sold them, and the department and its lawyers have these records. In a statement sent to ABC 15, the Phoenix Police Department spokesperson said they did not participate in, encourage, fund, or sanction the creation of any such challenge coin. There is also no indication such a coin was used for any public or official purpose on the department's behalf. A review at the time by a commander with the department was unable to substantiate any claims of misconduct related to a challenge coin. All right, so this statement came out first, and then Dave Biscobing is saying, yeah, they know it. They knew it. They know it exists. She was shown it during a deposition, so they're just flat out lying about this. Some followers have pointed out something very troubling about the message on the front of the coin kept by the Phoenix police officers. Google, good night, left side. It's based off of a neo-Nazi imagery and slogan. I did not know. City of Phoenix cannot ignore this. Okay, so now it's ballooning. It's becoming even potentially a neo-Nazi slogan. Let's be very clear. Some of the officers who handled the BLM protest response and arrests of BLM supporters kept, shared, or sold this coin, and the Phoenix City Police Department didn't care. Read my story for their statements. One such iteration of good night, left side. Okay, so it's a different phrase, which I had never heard of. Disturbing neo-Nazi stickers have started appearing in central London. Okay, never heard of that. The sticker is representative of the potentially more violent form of neo-Nazi activism. Its use of a Dodge Charger vehicle is a disturbing and deliberate choice following the terroristic murder of Heather Heyer in Charlottesville. It is intended to threaten communities and individuals they perceive to be on the left, there in quotes. Right, so you have this, good night, left side, a neo-Nazi symbol. Another one, good night, left nut. Is it similar? Yeah. Is it the same? I don't know. We've got 3 versions of this coin being passed around. They knew it. Phoenix police didn't do anything about it. Here are some statements from them. Joint statement from the police chief, Jerry Williams, and city manager, Ed Zucher. There are disturbing claims that members of the Phoenix Police Department circulated an inappropriate challenge coin related to the 2017 incident. This is unacceptable and not in line with the behavior expected of my officers, said Chief Jerry Williams. I not only expect more, but demand more from my officers. There are now new allegations that the language on the coin may be connected to hate speech. Hate speech. Hate speech in any form is unacceptable, even more so from officers who we rightfully hold to the higher standards of excellence. Will not be tolerated. Will take disciplinary action against officers involved in any illegal or unethical behavior. So we'll see. We'll see. Working together with Chief Williams, I have instructed the city attorney's office to begin the process of an outside investigation. We do not accept hate speech at the city of Phoenix. It's unacceptable. We must have an independent look at these disturbing allegations. And Dave Biscobing is responding saying, remember, Police Chief Williams knew. Governor Doug Ducey just appointed her to the state police board. I cannot emphasize this enough. This statement makes it sound like Chief Williams didn't know. She knew, and she knew 1.5 years ago. She was shown pictures in a deposition. Watch my story. I put the depo transcript in there. Okay, so that was their statement. Oh, no, we had no idea. No, I mean, are you serious? Nazi imagery on coins? Wow. All right, so we've got a new reaction on the coin kept by Phoenix police officers. This one comes from PLEA, the Phoenix Law Enforcement Association, our police union here, which is the subject of continual criticism by yours truly because of what they do. The main union for rank and file police officers released this statement. President Michael Britt London said the role of the Phoenix Law Enforcement Association is to promote the positive role of the police profession, a task that we do not take lightly. We do not condone hate in any form. That is not what we stand for as police officers. The recent reports about the creation of a controversial challenge coin are concerning, and we trust a thorough investigation will provide additional information, at which time appropriate action can be taken. So what we're asking for now, or what many people are asking for, is who knew what and when, and why was this covered up for so long? Why is this only now sort of coming to everybody's attention? Well, it's because Dave Biscobing, that's number one. But why were our elected people? Why was our chief of police? Why was PLEA, who presumably all knew about it because they had depositions years ago? Why is Alistair Adele, the county attorney? What are they doing about any of this? Well, here is Dave Biscobing. He keeps digging in. He says, the cases go on. She promised to do what's constitutionally required to anyway. We asked the below questions. We got the following answer. So Dave sent her these questions. What is the Maricopa County Attorney's Office position on the challenge coin and its ties to hate speech? Are you going to answer that? What actions will the County Attorney's Office now take to ensure these cases are fair and just and not tainted by officers who possess trophies tied to hate speech? Okay, those officers have been prosecuting a lot of people. They've been arresting a lot of people, charging them with crimes. They're carrying around hate speech, neo-Nazi propaganda. All right, is that going to impact your criminal case? Good question. Will MCAO collect and gather records related to the coin to ensure it's properly disclosed to defendants? So if you're charged with a crime and one of these officers was in possession of one of those coins, would you ever even know about it? Wouldn't you want to know about it? Right? If you're a defendant and you've got this cop carrying around what allegedly might be Nazi propaganda, or at least a highly inappropriate promotion of violence, I would say, right? Getting glee off of firing rubber bullets at protesters and hitting them in the groin as though it's some sort of a joke. Specifically, will the office review and reevaluate the protest cases, including the gang case? And so this is where things get a little bit squirrely. Now, the police are claiming that a lot of these protesters are, in fact, part of a gang, right? They're sort of trying to increase penalties for them. In Arizona, we've got some gang modifiers. Essentially, if you're a part of a gang, you're charged with an underlying crime, and you get gang terms, right? You add on these additional penalties because you're a part of a gang. Well, what our county attorney here has been doing has been saying, well, these sort of qualify as gang behavior. We're going to show you what they mean. So Dave Biscobing sent those over to the county attorney. County attorney responded. She said, recent reports of a challenge coin with alleged ties to hate speech created by members of law enforcement are very troubling. We do not have the results of an investigation. I want to make clear any information provided to my office will be carefully reviewed to ensure proper disclosure takes place. So they're saying we're going to get copies of it if we see it, if our officers had it. If you're a criminal defense attorney in Arizona, it might be a good time to make sure you're asking that question. City Phoenix manager tells ABC 15 they hired an outside law firm to handle the investigation. There was a review in 2017, but no records, and officers under the investigation are being reassigned to non-enforcement positions because they know, right? They know if they were in possession of that, they got to tell defense attorneys. Defense attorneys are going to have a field day with that. Rightfully so. Totally inappropriate. Totally inappropriate. Now, what is the Maricopa County Attorney's Office going to do with these protest cases, right? You see this all around the country, not just Arizona, but a lot of people are protesting and they're being prosecuted for protesting. We've seen it all throughout the summer stuff. Even people who were there at Capitol Hill, they're getting arrested even though they weren't in the Capitol building. Okay, we've covered several stories where people were outside of the Capitol building or they arrived the next day. We talked about 2 people like that. One person was arrested the following day for basically getting into a street fight with somebody the next morning or the next evening. I don't know. Wasn't there, but the media was saying this guy was a monster. He was threatening to kill Pelosi. He was part of the Capitol Hill riots. What a disaster, right? And he wasn't even there when it was all going on. He was there the next day. So you're starting to see on both sides, right and left. Okay, these protests were all about BLM and Antifa and the summer unrest. I think. Is that what that was? I can't even keep track anymore. There's so many protests going on in this country. But that was that, right? And Trump's people are getting arrested. Democrats' people are getting arrested. Now the question is, what are they going to do with those charges? Are they going to consider them to be gang members? Well, what's MCAO going to do? Defense attorneys and community leaders are calling for controversial gang charges against protesters to be dropped after learning that the Phoenix Police Response Unit possessed commemorative coins with neo-Nazi-inspired hate speech. Maricopa County Attorney Alistair Adele dodged questions on Monday, but she did call the report very troubling. Another law firm's getting involved, as is the mayor. City also told ABC 15 that Chief Jerry Williams will place officers under investigation and in non-enforcement assignments. They don't want him to continue to go write tickets and arrest people if those charges are going to be thrown out because they're neo-Nazi racists. It's not clear if any officers have been identified by the department and reassigned yet. ABC has confirmed 5 officers have admitted to possessing the coin in court testimony. Officer George Herr, Jeffrey Howell, we've got Glenn Neville, we've got Jay Scott, and John Sticka. So 5 Phoenix police officers who have been confirmed to be in possession of it. ABC 15 viewer also provided images from a 2018 eBay sale showing the coin for sale by Burry Bryce, another Phoenix police officer. Phoenix's response to the coin has evolved in recent days, beginning first in a dismissive statement that distanced the city from any such coin, so they're backtracking hard. On Friday, Phoenix police told ABC 15 that a commander did review at the time but didn't find any misconduct. No, they didn't find any misconduct because they investigated themselves. They did a very thorough job. They looked hard, really hard. They had some hard conversations, talking to all sorts of people, digging. Are you sure? But at the end of it, no misconduct. Nothing even to worry about. Nothing to even report about. Not even any discipline. Status quo. A couple more years. In response to the follow-up questions, the city confirmed the commander who did the review was Brad Burt. Spokesman said there are no records related to this supervisor review because it probably didn't happen, folks. That's why there's no records. Phoenix Tactical Response Unit and its sergeant, Doug McBride, have been heavily involved in several controversial protest arrests and prosecutions. In one case, McBride testified before a grand jury to charge a group of protesters as a criminal street gang. His testimony is full of exaggerations and false statements. No surprise there. According to multiple defense attorneys, he repeatedly compares the groups to notorious street gangs like the Crips, the Bloods, and the Hells Angels. Sergeant McBride is the same so-called gang expert who either ignored or missed the fact that members of his own unit created and shared the challenge coin modeled after the neo-Nazi paraphernalia. What this demonstrates is that he has no credibility, should not be allowed to shape the prosecution of these protesters. So this is the guy, Doug McBride, right? He says he oversees the unit with many members who kept the coin, is the same one who testified before the grand jury the street gang charges against protesters. And here's how he justified it. How did they create this fictional gang? A woman by the name of Amy Caper says she's not a gang member. She's a graduate student. She doesn't run drugs, traffic guns, work in any organized crime ring, but she did protest police violence last year. And what happened? Well, the Maricopa County Attorney's Office, the prosecutors here, and the Phoenix Police, they're prosecuting her and a group of 17 other defendants, including 3 minors, for being part of a criminal street gang following an October 17th protest in downtown Phoenix. In fact, officers and prosecutors allege the group is dangerous, and in some ways more dangerous than notorious gangs like the Crips, the Bloods, and the Hells Angels. Caper and other defendants could face 8 and 32 years in prison, between 8 and 32 years. The gang charges, based on broad and easily abused statutes, are a clear, quote, political prosecution. You're kidding me. You're kidding me. Intended to silence dissent and scare protesters from organizing. according to community activists and groups like the ACLU. Arizona statutes say that the criminal street gang classification are so broad, they only require 2 of the following criteria to be met: self-proclamation, witness testimony or statements, written or electronic correspondence, paraphernalia or other photographs, tattoos, clothing or colors, and any other indicators. Phoenix Police Sergeant McBride, a grenadier who manages the tactical response unit and former gang detective, testified that all members of the group meet the criteria for 3 reasons. The first is chanting "all cops are bastards," which he claimed is self-proclamation. The second was that most of the group was dressed in black, which meets the colors requirement. And the third was that many of them carried umbrellas, which he claimed was part of their uniform. There you go, folks. So if you are, dressed in a Super Bowl sports jersey and you're walking down the street shouting something about Tom Brady being amazing and you have an umbrella in your hand, you are a part of a criminal gang, according to this Sergeant Doug McBride here from Arizona. Okay, do the police meet those standards? Let's see. Do the police meet those standards? Self-proclamation. Okay, they all say the same things largely. Witness statement, testimony or statements, written or electronic correspondence. Yeah, they communicate with each other. Do they have paraphernalia or photographs? I would say so, right? They all take group photos together. They all take headshots. They all have photographs. They all go on the walls. So yeah, they've got groups of photographs. They have tattoos. Yeah, many of them do have tattoos. I don't know if there's any rhyme or reason to them, but it doesn't say anything about that. Clothing or colors. Yeah, I mean, they all wear uniforms. They all wear badges. So you need 3. Okay, photographs. We got correspondence. We've got color. There you go. The police are a gang. You're welcome, Sergeant Doug McBride. So that's what's going on in Phoenix. That's going to be a lot of fun. This is going to be a scandal that just keeps, the tentacles will just keep spiraling out. So if you are somebody who's interested in that, buckle up. It should be fun. So we're going to continue to cover that. We hope you join us. Good reason to subscribe and be a part of our channel. All right, let's change gears yet again. I wanted to wrap up today with a little bit of a segment on Ghislaine Maxwell. Ghislaine Maxwell is somebody who we've been sort of dabbling on. We've covered this case here and there. And the reason why I'm so interested in this case is because she has some just behemoth attorneys working for her. I don't even want to know what their cost, but I am very curious as to what they're doing and how they're going to be defending this woman. So I've been following it for some time just to figure out sort of how they structure things. You know, I'm always trying to learn from other attorneys and see, man, that's a good idea. Maybe we can take that and use that for something that we do. Now, I've never represented anybody as high profile as Ghislaine Maxwell for charges like she faces on a federal level, right? This is a very high profile case. She's got a ton of money. And so she's got just, behemoth attorneys who are out there working on her case. And so I've been very curious just to follow along. And it's been a hard case to follow. This is not one of those that we can just sort of, read the court documents and I can go, oh, I see what's going on here. That argument. So it's sort of like, building a house. Okay, we're going to paint that this way and put that finish over here and buy a couch over there. And you can do that with criminal law. You can say, okay, it's this defense and this case and this argument and due process here and whatever. And so we kind of have been following along Ghislaine's case, but most of her case is under seal. It's confidential. It's not disclosable. This is what I'm talking about. This is a motion that she recently filed, and we don't know anything that's in this paragraph. What are they talking about here? And this has kind of been the same thing that's been going on for a long period of time. And now it looks like the judge may be taking some of this away. We may be able to see what is going on behind the scenes. I'm going to show you what we're talking about. But this comes from one of her, so what they've been battling about. There were 2016, there were depositions where Ghislaine Maxwell was being interviewed in a civil claim by Virginia Guffrey, who you may have seen if you've watched any of this stuff on Netflix. Not a real good series in my opinion. It was very emotional and not particularly legally interesting, but some good backstory there if you want to go check out that series on Netflix. I digress. The point here is that they were arguing about releasing and unsealing some depositions that took place in 2016. A deposition is it's a formal court proceeding. You're on camera. Everything is being recorded, transcribed. You're under oath. And so you got to be honest about this stuff. Well, there were these depositions that took place, and there were some hard questions, apparently, for Ghislaine Maxwell, who was Jeffrey Epstein's number 2, allegedly helped him, what's the word? nurture, curate. I can't think of the word. It's on the tip of my tongue right now. But whatever it is, she's grooming. There it is. Grooming underage individuals to basically be, sex slaves for Jeffrey Epstein. Pretty gruesome stuff. Now, what she's talking about here, we don't know, because during the deposition in 2016, these questions came up. They had some arguments about them. The different higher level courts turned around and said, yeah, you got to answer those questions. So she came back down. They did answer the questions. And now the courts are trying to open up those records. The allegation here from Ms. Ghislaine Maxwell and her defense team is that she made these statements under the belief that they were going to be sealed and confidential and protected forever. Now that you're opening them up, that is a violation of her rights, right? She made them with these guarantees of protection, but now that you're trying to open them up, you're violating that. She wouldn't have made those statements if you knew that they were going to be opened up. And so what they're talking about here in this document that I'm about to read you is their request that the judge continues to keep it sealed. They've been fighting over this stuff for a long time, and they're saying, you got to keep it sealed. Here's why. If you open it up, there are other people, not just Maxwell, who are going to be harmed by this information getting out. So presumably they're talking about they're talking about it as it's consensual sexual activity that she is engaged in, and presumably we can't tell what they're talking about because it's all blacked out like this. We can't see it. But the concept here is that there are other people who are involved in whatever that consensual activity was who might be harmed. And therefore, if they were to release this stuff open, if they were to unseal it, those people would be legitimately harmed by it. So let's read this. This is where they're making their argument that all of this stuff should stay under seal. Relying on the confidentiality protections of the protective order, Maxwell declined to invoke her privilege against compulsory self-incrimination and agreed to testify at the April 2016 deposition. So she's saying, we entered into an agreement, a protective order. We didn't invoke her privilege against self-incrimination. We didn't plead the fifth. We agreed to testify because of the confidentiality protections. And then in that deposition, all of this stuff happened. Nobody knows what that says. Okay, this is kind of the curious part. Following the deposition, Guthrie moved to compel Maxwell to answer additional intimate and personal questions that she had previously declined to answer. In support of the motion, Schiller assured the district court that, quote, such questions are entirely appropriate in the discovery phase of the case, particularly where any answers will be maintained as confidential under the protective order in this case. So at the time, contemporaneously with her conversation, they were saying, yep, all of this is going to be protected. It's not going to come out. Now, look again. This is the next slide. Look at all this stuff that's blacked out. We can't see it. It's all redacted. The district court granted the motion in requiring Maxwell to answer highly intrusive questions, quote, relating to her own sexual activity and her knowledge of the sexual activity of others. The court held that Maxwell's privacy concerns are alleviated by the protective order in the case. In other words, the court is making sure that the information that you are detailing during the deposition, we're going to make sure it's protected. It's not going to get out. So don't worry about that. Talk about what you're willing to talk about, because it's going to be confidential. Now, not so much. And they're saying you're violating a prior agreement. Secure in the belief that the protective order would be honored, Maxwell appeared at a second deposition and answered hundreds of pages worth of questions about what is this? And someone else, what is that? From the very first question, Maxwell discussed, redacted. She was asked, redacted. Next sentence. She was also asked, redacted. We can't see any of it. What are they talking about? What's so important about this? It's killing me. What are they talking about? All right. Here is the order that came down from district court. This was filed yesterday, February 8th, page 1 of 3. Not a long order. It says, in response to Maxwell's counsel's letter, in ordering the continued sealing of its order on January 19th. So there was a prior order. So this judge has slowly been sort of opening the box a little bit, letting some of this stuff out, and then they're going back through this. And you can look this up in the court record. It's pretty interesting, actually. I think hundreds of pages. I'm not sure how many pages, but they have basically this table in a Word document, and they're going through and they're saying, okay, this paragraph, this sentence, we want it sealed, and they give a reason. Next one. We want this sealed. Here's a reason. Next one. This one is not important. Don't need it sealed. Next one. This one was already made public. It's irrelevant, for like 100 pages. I mean, just a ton. They're analyzing every single sentence, every single syllable, every single comma is being argued over in this criminal case. which is not particularly common, right? This is a little bit out of the ordinary. And now the judge has said that this is some of this can be made public. Some of this can be released, but they're going to be weighing a couple different factors. They're going to be deciding whether or not the public has a presumption and a right to know versus protecting her privacy. So you've got these two competing interests going against one another, whether the public has a right to know versus whether Ghislaine Maxwell has a right to privacy. Pretty compelling interests at each other's throats. So let's go back to this order. It says Maxwell's testimony was pertaining to private sexual activity with consenting adults, and the testimony and identifying information of a non-party does, so that's other people who were not there, who have not been considered for unsealing, the court considered, as it did during the last round of unsealing, the reliance of these parties on the case's protective order. So this is kind of a botched paragraph. I didn't like how that was written, but it says here, as Maxwell points out, the Court of Appeals recognized that the third-party reliance on the protective order warranted the continued sealing of some materials in this case. So Maxwell in her motion said, yes, Court of Appeals noticed that there are third people here. You know, if you unseal this stuff, it just doesn't hurt Maxwell. It hurts other people who are part of the depositions. And so, yeah, you may want to keep some of that stuff secret. In considering for unsealing the materials at issue in its January order, the court also considered this reliance when it undertook its particularized review. And so that's where they're going through that table, hundreds of pages, and just, you know, detailing what was done in the deposition. Concluded that some portions of this case's materials should remain under seal. So some of that stuff was under seal. Now we get to some law. Reliance on the protective order itself. So they're talking about, you know, as I sort of frame this out, Ghislaine only made these statements because she thought she was being protected, that it was going to be confidential. And what this court is saying, yeah, but that doesn't just on its face per se, that doesn't just automatically outweigh the public's right to access the deposition. Okay. In unsealing the summary judgment, the Court of Appeals redacted deposition responses concerning intimate matters where the questions were likely only permitted and the responses only compelled because of a strong expectation of continued confidentiality. In recognizing this reliance interest, the Court of Appeals did redact some of her testimony related to her consensual sexual activity with adults, but it unsealed testimony relating to purportedly non-sexual massages, finding that the presumption of public access was not outweighed by the private interest in sealing this portion of her testimony. So what they're doing is they're just breaking this down sort of paragraph by paragraph, line by line, and they're saying this is protected because it's closer to consensual sexual activity with adults. This is less protected because it's a non-sexual massage. And just going through the deposition item by item. Here is the final page of this order. We have one more. Consistent with the Court of Appeals directive, the court considered the reliance of Ms. Maxwell and others in the order and directed materials unsealed where this reliance interest or other private interests did not outweigh the presumption of public access attached to these materials. So in this order, the judge is just saying, look, weigh those out, okay? Balance those out, and then we'll decide what should be released and what should not. There was a second order that also came out. So when this was coming down, Ghislaine and her attorneys, they filed a motion to reconsider, which is basically asking the court, hey, we know you ruled this way, but we really want you to reconsider that. Okay, here's why. You missed this, you missed that, you missed this. And so that's what this next order is. We're going to go through it quickly. It says, before the court is Ms. Maxwell's motion seeking limited reconsideration of the court's order, which is, look how much, we're not unsealing a lot. They're fighting over a lot of, very little information. This court order is unsealing 20 lines of Ms. Maxwell's July 2016 deposition transcript from page 112, line 17 through and including page 113, line 12. Very specific. Ms. Guffrey and non-parties Julie Brown and Miami Herald Media Co. oppose the motion. So they want this information to come out. Maxwell is saying we want it protected. Guffrey and others saying we want it out. For the reasons described below, Ms. Maxwell's motion is denied. Court goes on. She submits the court should reconsider its order unsealing on the basis that this portion of the testimony falls within the category of adult consensual activity that warrants sealing. To the extent that the testimony was not sexual in nature, it was outside the scope of permissible deposition questions. Number two, Ms. Maxwell's reliance on the confidentiality assurances of the protective order outweighs the public interest in her testimony. The court already said, nah, we don't think so. Because public release of this section of testimony will make it more difficult for Ms. Maxwell to suppress this testimony as evidence against her at a criminal trial. Right? And that's probably the biggest one there. Might be something in there that they really don't want out. The court declines Ms. Maxwell's invitation to consider its order unsealing portions of her testimony. First, Ms. Maxwell's motion does not meet the reconsideration standard. She points to no change in the law, no new evidence, nor any clear error on the court's part. So you need those things in order to be successful on the motion. The court already weighed the evidence. Just because you don't like their opinion doesn't mean you get to go in and ask them to change it again. You got to find something else. Change in the law, clear error on the court's part, new evidence, any of those things. Maxwell doesn't have them. She made in her original objections to the unsealing of the 3 points she raises for the second time in her motion. The court considered each argument already heard it. Accordingly, the presumption of public access is somewhat less weight than for a dispositive motion. Nevertheless, it's important that the public interest in monitoring federal courts' exercise of their Article II powers, that the public reviews the documents. Public access to certain parts of this transcript is outweighed by Ms. Maxwell's countervailing interest in resisting disclosure of details. Goes on. Let's see what else we have. All right, we got second, and more importantly, there is no reason to unseal this portion of the testimony. It does not relate to private sexual activity of consenting adults. There is no reason not to unseal this portion of the testimony. It's a pretty important word there. It does not relate to the private sexual activity of consenting adults, but only to massages. Miss Maxwell's privacy interest in such testimony is minimal, and as the court determined when it unsealed this portion of the testimony, any private interest she has in sealing this portion of the testimony does not outweigh the presumption of public access that attaches to it. And then third and lastly, while the criminal court acknowledges her interest in a fair criminal trial, Ms. Maxwell can argue all her points to the presiding judge in her criminal trial, as she already has. See her memorandum. She'll still have all the rules of evidence at her disposal and procedure, just like any other criminal defendant. To the extent that Ms. Maxwell can show at her criminal trial that the government improperly obtained this section of her testimony ahead of time, she can argue about whether the sanction of suppression is warranted. For these reasons, her motion for reconsideration is denied. Signed again by the same judge, Loretta Preska, Senior United States District Judge, New York, February 8th, 2021. So, this is one of those that it's kind of hard to have an opinion about because you don't know what they're arguing over. You don't really know what is that. Right? It's hard for me to come in here on here as a defense attorney and say, well, this is a good fight worth having, because I don't know what they're talking about, but they are putting a lot of effort into this. They do not want this to come out. If you go back and look at the court docket, they've been fighting over this for a long time. So it's just a couple paragraphs in there, but what does it look like? And let's take a look at the entire memorandum that her team submitted. This is from Ghislaine Maxwell. This is what it looks like if all the pages are spread out. And look how much of this is just redacted. Even like from the table of contents, redacted. Introduction, redacted. Major redactions across the board. Whole block paragraphs of stuff that is just excluded. Look at this over here. 2 paragraphs over here. Variety of sentences all the way throughout. So this case has just been interesting because we just don't really know what they're doing, because everything is under seal. Her attorneys are being extremely aggressive. None of the public access records are available. They're all redacted, and the courts are upholding a lot of it until now. So we'll start to see if any of this continues to come out. All right. And then our last little, it's not often you get a feel-good legal story that happens in court, but we had one today, and I want to share this with you. Before we jump into our chat portion of the program, there was a court proceeding that took place on Zoom, and which is happening a lot nowadays. Right? A lot of these proceedings are happening on Zoom. It's kind of funny that people kind of are still having some Zoom issues, but it's going to happen. We all have them. Zoom performance issues. Oh, don't you hate that? Very embarrassing. But what we have here is kind of a fun one. This attorney calls into a formal court proceeding, and he has a filter on his webcam. So sort of like you have on your phones when you can, do a. I don't have an iPhone because I'm an adult. But if you have one, I think you have your animojis where you can put your face in there and move things around, and it looks like you're an animal or a creature or something like that. Well, that happened in court today. Let's take a look at what happened on the Zoom proceeding in court.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to
Can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that.
Just outstanding. I'm here. I'm not a cat. And what I really like about that is he was just ready and prepared to move forward. So hey, Judge, look, I'm not a cat. I got my arguments. I'm ready to rock and roll, buddy boy. Let's get this show on the road. I can appreciate that. So a little bit of a fun thing to wrap up the day. All right, so let's jump into some of the questions. As a reminder, this is all taking place over on locals.com. However, if Miss Faith or Mr. Ma, if we see anybody in YouTube, feel free to clip some of that stuff. Just we don't want to forget about our YouTube brothers and sisters over there. Okay, we gotta be very inclusive here. YouTube is we're gonna work our things out. I think with YouTube, we're gonna make it work. But this is a good time to chat. So watchingthewatchers.locals.com. Go on over there. There's a live chat. As long as you are a supporter over there, then you can ask a question. You don't have to pay separately for each question. If you're just a regular monthly supporter, unlimited questions. It's kind of an upgrade. So head on over there. And our first question today comes over from Hack Consulting. Says, is there a way to sue possible class action those who defamed Trump supporters these last 4 years, calling us Nazis in order to direct rage against us and such? Good question, Hack. I don't think so. I think, the closest analogy that I can think of would be what happened with the Covington kids. Remember when, I forget his name. It's escaping me right now. I follow him on Twitter. One of the kids who I think Lynn Wood was actually representing him sued a bunch of them, and it was successful for him, right? He sued them, filed defamation claims, and he won, or at least settled. I think a lot of them were non-disclosed, but he settled those claims, and I think that worked for him because it was him specifically. Right? It was one individual. They were calling him out. It was singling a group of individuals. It was a small group. So in terms of, what you could do with several hundred people, I think, maybe a class action would be something worth organizing, but it's not my area of law. So I don't want to sort of, spin off on that too much. I just think that, the point here is the bigger the audience, the more spread out the claims would be. So in a defamation case, you got to go prove that they intended to do certain things and it did actually cause you harm. If you're a small group like the Covington kids were, then each one of them can show specific harm. They can show how they were directly impacted by this. The main guy who was on there, the main kid, Kyle Kashuv, I think is his name now. He was, he was all over the news. It was his face. People were saying he was beating the drum. He was, in front of the other fellow who was there, and it was him. He got harmed by that. So he could show where the harm came from and make a claim that I think is strong. If you want to make a claim about 70 million Trump people, I don't know how you would quantify the harm for them. It'd be sort of like a generalized claim, and I just don't know that would go anywhere. Good question, though. Liberty or Death says, I see that Senator Kane's idea of censoring President Trump of the 14th Amendment to prevent him from running again is picking up steam. I don't see how that would be anything less than a bill of attainder either, which is what a conviction in the Senate would be. Yeah, it's a good point, Liberty or Death, and I think this is going to be very interesting to see where this argument goes. So what he's talking about specifically is after this impeachment fails, we all know that it will, he's not going to get convicted. Democrats are already looking for other things that they can do. They're grasping, they're trying. They really don't want Trump to run again. And one of the things that they're trying to do is say, all right, well, we can censure him under the 14th Amendment. And what they can do is then sort of invoke that incitement of insurrection under the 14th Amendment. They can pass that just by a simple majority, 51 votes versus the 67 that they would need to convict him in the Senate. They can just pass it with a much smaller margin and still preclude him from running again. So some of the issues that pop up are exactly what Liberty or Death is talking about. Specifically, is it a bill of attainder? Right. And the response, at least as it relates, so a bill of attainder is getting so ahead of myself here. Bill of attainder is basically the legislature acting as a judicial body and punishing somebody for their conduct without the official sort of due process that you would see in a court of law. You don't want the legislative branch acting like a court. You want the courts acting like courts. That's why we have a judiciary. And so if the legislature is trying to, sort of process private citizens through a pseudo judicial process in the legislature, we're not allowed to do that because our Constitution says so, because the founders didn't like when England was doing that to them. And I think even some of the earlier colonies were also doing it. So they just said, nope, no more of that. If it's a judicial process, go to the courts, don't do it in the legislature. So the response that Liberty or Death is bringing up is, well, okay, Trump's a private citizen now. So if they want to prosecute him according to the 14th Amendment, that is a bill of attainder. That's not allowed. It's prohibited under the Constitution. So the response, that same issue is actually apparent right now, right? Donald Trump's a private citizen at this moment in time. The Democratic response has been, well, they impeached him while he was still the president. The trial didn't start, but we impeached him while he was president, which they did. And so they're just carrying this out further. So the prosecution started when he was not a private citizen, therefore it invalidates the bill of attainder stuff. Well, in this situation, if they're going to try to renew this under the 14th Amendment after they lose the impeachment proceedings, then this would be a new cause of action. Arguably, in my opinion, it's an entirely new cause of action. It's a censure. It's not an impeachment. It's different. And so, in my opinion, it would be a bill of attainder. But I think their response is going to be the same argument. They're going to try to connect that back to conduct when he was the president. And they're going to make the same sort of asinine arguments that they're making today. Good question there, Liberty or Death. All right, Ryan says, that first defense lawyer for Trump was unbelievably horrible at his job. Lots of rambling, losing his train of thought, awkward pauses, forgetting things. I know, I had to turn it off. I'm like, what am I watching here? It was embarrassing. And I was reading somewhere else that was an intentional strategy. Basically that he was responding to the emotional pleas of the Democrats. You know, they came out there with a very emotional statement, 12-minute, 17-minute video of all the mayhem. Raskin comes out there, said, we just buried my son. My 6-year-old daughter's here. It was a nightmare. Horrific, right? And so the Republicans, or Trump's defense attorneys, were going, yeah, that's pretty bad. We got to change our strategy. They may have been sort of going into it with nuts and bolts, constitutional arguments, jurisdiction, severability, whatever, due process, all of the arguments that we covered in their memo. And then they saw that. And so he just went out there and he's like, all right, I'm just going to riff on how great the Senate is and how great America is. And he just kind of slapped his argument together. And if that's what happened, he did a terrible job at it, right? Terrible. The fact that you can't go out there and pontificate about how great America is for 45 minutes, just ad-libbing stuff, is not good. We're going to see what happens with that lawyer. We have Jeremy Matrida says, I watched the proceedings today. Was painful to watch. The Democrats played a propaganda video and the defense made a very compelling case that this is not constitutional. I think that's probably a pretty fair analysis. I would give the defense a little less credit. I think half of them made a compelling case. The other half, not so much. Ryan also says, the fact that it fails the incitement test vis-a-vis Brandenburg should have meant that this impeachment should have gotten anywhere near this far. Should not have gotten anywhere this far, I think, is what he's saying. Yeah, and so as you went through my flow chart, right, Brandenburg was right there. If they can't prove it's incitement, then it's all done. It's over. It's the end of the conversation. We have Chris Wiseman says, my recommend defense strategy will be to spend 2 hours reading transcripts of Dem tweets, post clips, calling for incitement calls to action. Gorsuch hearing, Capitol's being stormed. 2016 election was hijacked / Russia, and the Time article. Yeah, pretty good. Pretty good list there, Chris. There's a lot of stuff that you can talk about. And, I got this comment on Twitter from some guy who probably didn't really watch the show yesterday, but he said the same. He kind of had the same argument when he was responding to me on Twitter, and he said, just got a good laugh from Robert Gruler reading through the Chuck Schumer impeachment proceeding yesterday. And he said, wow, I wonder what reality he's living in, because in one version, Donald Trump gave a speech and they stormed the Capitol. In another version, Chuck Schumer gave a speech and there was no storming of the Capitol. There was no harm there. And he's going, yeah, see, how far off are you? And it's because this is a very common mistake. And I wanted to spend some time dissecting it at the start of the show. Okay, it's not about the harm. It's not about the damage to the Capitol building. It's not about the dead people. As awful as that is, and I mourn for them. I'm very regretful that any of this stuff happened. I think it was a bad day for America, and I've been very consistent about that. I'm not excusing that. But the question here is, how do you connect that back? If you can, then great, then do it, then prove it. connect it back to Donald Trump inciting the insurrection through his speech or through his prior actions. Just because something bad happened doesn't mean you can go and find whatever defendant you want and just pin it on somebody. You got to prove your case, and they just haven't been doing a good job of that. They're all deferring back to this harm. Well, the Capitol building, it's sacred. Great. That's great. But that's not the harm that we're talking about. The harm that comes from an insurrection is an interference with the operation of government. It's not damage to a building. Okay? If Donald Trump gave a speech outside of a Walmart and they stormed the Walmart, that's not insurrection. It could be incitement of shoplifting, incitement of a riot. If somebody got killed in there, incitement of murder, but not insurrection. But the building could be totally damaged. That's not it. So it's not the damage. It's not the deaths. They could have charged him for incitement for anything. They could charge him with incitement of murder for the police officers if they think they could prove their case. They can't, because legally and criminally, it's just not there. The evidence isn't there because he didn't do it. If you now brought, let's say you go back to the Walmart hypothetical, and you brought in Congress to count electoral votes in Walmart and you stormed Walmart, yeah, that would be closer to insurrection, right? Because now you're interfering with government proceedings. It's the interference that is the harm, not the damage to the Capitol, as bad as it was. And so when you're going to be making the claim that, let's say in the Chuck Schumer case, Chuck Schumer made a statement. It was responded to by the Supreme Court. They said, this is dangerous. We're going to continue on. That was interfering with the operation of a separate branch of government. The Democrats are trying to sort of finagle that. What they're really upset about is the interference. That's the criminality that's being alleged here. Now, they're not proving that. They're just saying like, what happened at the Capitol was awful. But it has to be an incitement of an insurrection, interference. That's why you can impeach Chuck Schumer. That's why you can impeach Kamala Harris, because the harm that they caused was the interference of the government. You don't have to storm the Capitol building in order for it to be insurrection. You can have insurrection for a number of other things. Anytime you're interfering with the normal functioning of a government. Schumer was doing it with the Supreme Court. Kamala was doing it with the bail bonds and the torching of the 3rd Precinct in Minneapolis, helping people get back out and onto the streets, interfering with government. I didn't set this standard, folks. I'm not making this up. This is their standard. This is what the Democrats put in their article of impeachment. I didn't come up with it. I think it's a stupid, ridiculous standard. That's why we're being so satirical with it. It's so low, and it can encompass anything that you can impeach anybody for anything. It doesn't even matter because it's a political show trial. It's not even connected to legal elements anymore, purely political. And you have a good list there. You have a good defense. Liberty or Death says on the 14th Amendment, President Trump would have to be convicted of insurrection for them to be able to use it to censor and prevent him from running again. Kaine wants to do this in lieu of conviction in the Senate. So he would have to be criminally charged and convicted, meeting the standards in Brandenburg versus Ohio. So censoring the president absent a conviction for insurrection would be a bill of attainder. All right, so I haven't really looked into what Kaine is saying about that. If that's the strategy he wants to use, that's a non-starter. I don't think that he would be convicted in a court of law, criminal law, a real court of law at all for what he said. And there's precedent for that. Okay, we covered some of it here. Hack Consulting says, yes, the impeachments of other nations tended to be political actions only. The founding fathers broke from tradition because those historical impeachments went against due process and other concepts they wish to have in their new government. Yeah, it's not, look, I understand what they're saying about no free speech, about, this being a political mechanism where you can punish people politically for it. Look, I get it. If that's what they want the standard to be, I think it's a sad thing in America. And I know I poke fun a lot of, about the government, but I want a functioning government. I think that we would have a much more functional government if it was about 1/10 the size, but we're all working on that. But here, when they're talking about impeachment as a political tool, the pendulum is going to swing the other way, guys. And it's just ridiculous. This is a waste of time. It's going to be a waste of time again sometime in the future. The Republicans are going to try to impeach some Democrat at some point for something stupid, and we'll be making the same arguments here. But, this is it. This is what it comes down to. We're having these political spectacles from all of our elected officials, people who we pay. They're wasting a ton of the country's time and money on all of this. There are many other things that we could be focused on, but we're not going to, because they want to go forward with something that they know is not even going to be successful. All right. We got Croc 1 Alpha says, all the Title 18, Chapter 115 sections in question refer to the government. Is the sitting president as executive branch also not considered the government? Unless he incited complete dismantling of authority of Congress and executive takeover of authority itself, how is that in any way insurrection or sedition? Yeah, so Croc 1, it just depends on how you define that, right? And we don't know what it is. So the only definition that we could take and use as an operative tool was exactly what they put in their article of impeachment. If they said that this was wrong, this was bad, this is what they said constitutes or warrants impeachable proceedings. Their standard was basically non-existent. Incitement of insurrection. And so when you boil it down, when you take all the fluff away, when you take all of the casualties, all of the damage, all of the videos and horrific stories from all of the major news companies, if all of that goes away, what you're talking about, somebody said something and it interfered with the government. That's kind of it, right? And that's a very low standard that I think anybody in this country can meet. Now, was it actually sedition? Was it really a coup? Was it really insurrection? No, right? No, they were back there. They were back in charge, arguably within an hour. They were back to business, arguably within 3 hours, 4 hours. They got back to counting that same day. Pretty weak coup, if you ask me. Chris Wiseman says, great analysis, worth listening to. TLDR, the House botched it with the snap impeachment. What they should have done was to impeach for dereliction of duty, which would have been much better standing, although still dicey because they failed to hold substantive hearings and investigations. Yeah, so that's a due process argument there from Chris. Basically saying, if the president is going to be charged with high crimes and misdemeanors, the impeachment process should at least resemble a criminal court of law. Impeachment for high crimes and misdemeanors. Well, we have criminal court of law. We know what that process looks like. We know that in a criminal court of law, if we walked into a court and the judge who is going to be ruling on the case was also the police officer who arrested our client, and they're also going to be voting on the jury on whether or not to convict our client, that would be a joke, right? A joke. And that's exactly what's happening today. We have another one from Chris Wiseman. It says, TLDR Part 2. Either treat it as a political cause of action and political treatment or a criminal cause of action and give it basic criminal standards of evidence and due process. The worst thing is to use a criminal cause of action and apply political standards of due process. Yeah, good points there, Chris. And, this is what we think it is. It's a political spectacle, right? That's it. They know it is. They all know it is. They're out there getting their 15 minutes of grandstanding so that they can run ads back in their districts. That's all it is. We have another one from Sarah Smothers. Rob, were you surprised by today's voting? If Trump had a more spirited crew speaking on his behalf, do you think things would still would be still moving forward? Good question, Sarah. I am actually not surprised by this. I think this mirrors a little bit of the vote that we saw. So remember, I think a week ago or 2 weeks ago, Rand Paul was on the floor of the Senate and he issued a point of order. He was basically asking the Senate to vote on whether or not they thought this was constitutional. And so I think only one vote changed, and I can't remember who that was, but it was, I think, 56-44 in the Senate today. And I think when Rand Paul had his point of order in front of the Senate, it was 55-45. So I think the presentation today flipped one vote, but that's it. So not much of a surprise. I'm actually surprised that one person flipped. I didn't hear anything today that would have made it unconstitutional a week ago and then constitutional today. But apparently one senator thought so. So I was thinking it was probably going to be in the same alignment as Rand Paul's votes, because you already had 45 or whatever the number was, 45 senators who said, no, it's unconstitutional. So for them to flip that, I think would be a tall ask. We have Liberty or Death says, I thought Schoen did pretty well until his slam poetry session. What was that about? So Liberty, I'm not sure that I caught that. I kind of was, after I checked out from Castor, I just was like, all right, that's it. The rest of the stuff, I was just watching clips. I really don't know what they were doing. I mean, they don't have to do anything, quite frankly. It's embarrassing that they weren't better prepared and they didn't have a fiery delivery. I mean, I was sitting there going, can I handle, you want me to go handle this right now? I'll make a PowerPoint. I'll do it. Just put me on the live stream. I'll do it. I'm ready. Put me in, coach. Because it was just that embarrassing. But I don't know. They don't need to do anything. Truthfully, they don't need to do anything. I think that Trump could just sit there, not show up, and he still's not getting convicted because there's just not enough there. Chris Wiseman says, oldie but a goodie. Disavow bad popos, pepper balls. Best unintentional headline ever. Pepper balls, tear gas after Trump rally. Yeah, I mean, that looks painful right there. That is painful. Pepper balls. That is just a double entendre. That's like a triple entendre, right? You've got the actual pepper spray ball as a projectile. Then when it hits you in your male genitalia, it explodes, and you have a different version of pepper balls. I am not condoning police violence. All right. This is ridiculous. These challenge coins should be investigated. And I hope that the people who were responsible for it get properly investigated and reprimanded. But pepper balls is pretty funny. We have Hack Consulting says, wait, what? Why are the coins alongside of that neo-Nazi symbol? Are they really inferring it? It's a damn image in a circle. It's like walking into a daycare and seeing a red triangular prism and freaking out thinking your child is now a Nazi because the Nazis once used a red triangle. Yeah. So, look, I don't know about that. I don't know about where that came from. I think it's worth an investigation though. I'm not one who instantly says, okay, well, there's that symbol, therefore that person believes all of this stuff, right? Symbols are very diverse. People use a lot of different symbols for a lot of different things. Just because you have a triangle, like in your example, doesn't mean you're whatever, right? So you got to be careful with some of that. But if you do have, look, there is a lot of smoke here where there's fire. We've talked about this. I talked about this, I don't know, a year ago on our channel. I made a bunch of videos about some of these LA gangs. We've got some LA, I forget the names of them, but there's a whole series of them in Los Angeles. There are these like literal gangs within police departments, sheriff departments, in a lot of these big cities, New York and LA and elsewhere. And they're like actual gangs. I mean, they have initiation protocols, they've got tattoos, they've got all this stuff. And so for me to jump into this, the next logical step and say, well, yeah, maybe this is something similar to that. It doesn't take a big leap for me. But I also understand your point, right? Just because it says good night, left nut, in my mind, that doesn't mean that it's Nazi imagery, but it's worth an investigation completely. All right, we got another one from Jack Elias says, since all National Socialism is and is only leftist ideology, no symbol concerning its ideology can occur on anything that is conservative. I see. Yeah. Yeah, Jack Elias. Yeah, look, I'm not particularly worried about the Nazi imagery as much as I am, because I don't know yet, right? I mean, that's still sort of speculative at this point. If it is true, if the guy who created the coin said, yeah, I'm a Nazi and I got my idea from this other coin. All right, well, that's pretty bad. But it could have been a situation where the police were just, oh, that's hilarious, right? That's pretty funny. I was there. I remember that. Oh, what a joke. It's sort of gallows humor that you probably have in your profession. You have it everywhere. Doctors have it. Lawyers have it. Everybody's got that, right? It could be that. Totally inappropriate. Totally unjustified. It doesn't necessarily have to be Nazi propaganda just to be totally unjustified. The fact that they have these trophies for injuring other people who are rightfully protesting, out there expressing their First Amendment right. I don't know the specifics of that specific protest, but, protest is allowed in this country. I disagree that it's effective. That's a whole separate story. You're allowed to do it. And if that guy was, otherwise operating within the confines of the laws, which is arguable since he's kicking pepper spray cans back at them. But then the question goes, well, they started it. And so you go round and around and around and around. The point is the police should not be exchanging trophies for their interactions doing their jobs with other regular everyday civilians. Not appropriate, regardless of where it comes from, what the imagery is. And the bigger issue here is not only, of course they were doing it, that's bad, but the police who were, this was brought to their attention. The chief of police, it sounds like a sergeant, McBride and others, they were all apprised of this. Not one of them thought, this is a problem worth investigating. Maybe we should document what we did here. It all just swept right under the rug, as is usual. Some indication that there was an investigation that was initiated, but nobody wrote anything down about it. Nobody responded to it. They investigated themselves, and they found that it was all fine. Not a surprise. Hack Consulting says, Hate speech is supposed to be protected under free speech. I don't agree with the ideology, but not all forms of speech are that of that ideology. Like, how are we going to have documentaries if we have no clue what they said and how they spoke of their ideology? If American history shows anything, it shows that we are all people and intolerance eventually resolves itself. Yeah, good point there, Hack. I think that's also a good point, right? Free speech includes all types of gross speech. You don't have to agree with them. But if you want to engage in real conversations, if you want to live in a world where it's just fake conversations, where everybody's too scared to actually say what they believe, we're going that way. So maybe you'll get what you want. Sharon Quidney says, there seems to be an overreaching theme in today's stories, the total absence of civility. There's no sense of empathy or compassion to be seen. It's like our whole society has descended into barbarity. That's an interesting observation there, Sharon. I had not noticed that, but I think you're right? It's sort of... The impeachment stuff was, I mean, it was mostly civil, I guess. Ridiculous, a waste of time. Yeah, we're in interesting times there, Sharon. But keep your head up. We're going to be all right. We're going to get through it. We got Chris Wiseman says at Faith Joy, not buying the story. No entries on Know Your Meme or Urban Dictionary for, quote, good night left side. The closest reference I could find is from the ADL, under an entry for anti-Antifa images. ADL is hardly neutral when it comes to anything right-leaning, much less alt-right. So here we go. So Chris is doing some digging right now. Other anti-Antifa symbology perverts the common Antifa slogans and logos, such as changing goodnight white pride to goodnight left side. Often anti-Antifa symbology implicitly or explicitly promotes violence against left-wing activists. So additional images. So it looks like the Antifa flag with a cross out. Good night, left side. So somebody looks like is hitting somebody with a chair. Anti-Antifa supremacist, it looks like. Anti-Antifa. Anti-Antifa worldwide. Destroy the red scum. Anti-Antifa USA. Yeah, well, first of all, Chris, thank you for that. That's outstanding. Research on the fly. Educating us in real time. Awesome. So I don't know, I don't know where that stuff comes from. Again, I don't really particularly care what it says. If they're still, they could have just had a picture of the guy getting hit in his genitals, and that's enough for me, right? They shouldn't be celebrating that like trading cards. And that's just a bad culture. If it's Nazi, yeah, that's even worse, but it's not the highlight of the story to me. We have no doubt says, I would like to hear Robert's thoughts on punishment modifiers. Whether it's gangs or hate crimes, the threshold seems low. It punishes for potentially unrelated activities or thoughts. So, yeah, I'm a criminal defense attorney. I think you can probably guess my position on sentence enhancement modifiers. I don't like them, right? I think that they are overly punitive. I think that this is stuff that politicians think sounds good. And it does sound good if you're in a red district or you're in a high crime district. We heard a lot about this in the 1994 crime bill and the preceding bills where they talk about the 3 strikes rules, boom, 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 mandatory sentencing. In Arizona, we have mandatory sentencing, right? So you have these 3 categories of offenses, category 1, 2, and 3. If you got a prior felony, you move up in categories until you get to the 3rd category. And once you're in that category, then you can sort of look at this chart and you've got a range of penalties. You've got a presumptive term, you've got a minimum term, which is what the defense wants. You've got a maximum term, which is what the prosecutor wants. And then on either side of those, you've got aggravating. So it goes presumptive, maximum, aggravating. Then you've got presumptive, minimum, mitigating. And there are some statutory rules in there on how you can move your result one direction or the other. And yeah, I've seen some pretty, what I would call totally unjustified sentences that are statutorily required, mandatory for people just because of a couple fact patterns hit, right? Couple criteria, boom, boom, boom. It hits that aggravated criteria, but it's not an aggravated case, right? This is somebody who is a good person, somebody who doesn't deserve that at all. But because it falls within that category, statutorily speaking, the judge has no discretion to move outside of that box. It's really disturbing, and it happens all over this country because of that. We have Nabarb Lesher says, yo, a bit off topic, but I don't know if you have heard of this case, Marsh versus Alabama, 1946, but if not, you should check it out. Let us know if you think it could work against big tech on the next episode. I think it's a pretty good argument. Thanks. A 1946 case against big tech. Ooh. My curiosity is piqued, so I will, I'll take a look at that. Miss Faith, can you write that one down for me? Thank you. All right, we got Jack Elias says, if they prevent Trump from running again, he will become more powerful as both a martyr and a martyr with a bank account and allies to go after the seats. Yeah, so I've sort of made that same point. You know, if Donald Trump is not allowed to run again, I think he's going to be even more, more vocal. Well, I don't know what he's going to do, to be honest. I think a lot of people feel like he's that way already. All right. Smother says, purely speculation. What if Trump is impeached? Your thoughts on what that would mean? So I would be very curious to see if Donald Trump would take this up any further litigation, right? Basically appeal this to the Supreme Court is what I would expect him to do. If he is ultimately convicted, I don't know what the precedent is for that, right? Where would he take this? Over to the Supreme Court. He would say it was an unconstitutional proceeding. I'm going to be appealing it. This is the court. They get to rule on how this happened, right? The Chief Justice wasn't even presiding over this thing. So would they invalidate the conviction? Would they overturn it? Would they abstain from it? Would they uphold it? I don't know. If he's convicted, I think that's what would happen. And truthfully, if I had to extend that further, I would probably say that the impeachment would not stand. I think that the Supreme Court would come back and say, no, it was unconstitutional, shouldn't have happened, and they would overturn it. Imagine that. That's also the more interesting story, rather than them refusing to grant certiorari or to not hear it. Be way more interesting. What if Donald Trump is convicted, appeals to the Supreme Court, they overturn the conviction, he runs again in 2024? Could you imagine? Oof. All right. We got Rob. So are you going to hire legal paraprofessionals when they get licensed here in Arizona? How do you feel about the new gig work? Oh, OSOC. This is a kind of in the weeds question. I appreciate it, but a lot of people probably don't know what you're talking about. Arizona recently passed a new rule that says you can have these things called legal paraprofessionals, and they can actually sort of do some things that a lawyer can do. It's part of this movement now to have more people have access to legal services, right? Instead of hiring an attorney at whatever it costs, you can go hire a legal paraprofessional for a much lower rate. And a legal paraprofessional, I think they just have to get certified. It's a small course, whatever that looks like. In other words, they don't have to go to 3 years of law school. They don't have to take the bar exam and get, certified and all that stuff. They have a much lower threshold. So I'm not opposed to it at all. I'm sort of opposite of a lot of other attorneys. I think a lot of attorneys in this country think that they are the gatekeeper of knowledge, right? They've got all this information in their head. I'm so smart. I've been practicing for 20 years. Look at me. I know everything. And if you want access to that information, you got to pay for it. You got to pay good money for that. And I think that worked, in the 80s, 90s, before the internet. And I think there are still a lot, 2000s even the 2010s. There are a lot of attorneys out there who still act as the gatekeeper. They don't want to give you information unless you pay them for it. And I think that's just kind of an old model. I don't think that works. It still works, obviously. A lot of attorneys are making a lot of money that way. But I'm just sort of on the opposite side of that. I think that the best way that we can help improve our criminal system, our entire society as it relates to law, is to just give the value first. All right, I've got probably 450 videos on this channel before we started this show where I'm just talking about the law, right? The very nuts and bolts of the law. Very bland, not interesting. If you go check out our new Arizona law channel, you're going to see that, right? It's not political commentary. It's not a show. It's not current events. It's just information about how the law works, and it's out there for free. I'm not trying to make you pay for me to answer your question. In fact, many of those videos I get emails about from people saying, hey, thanks so much. I'm sorry I didn't have to hire you, but thanks for helping me with my case anyways. And my response is always happy to help. Glad you didn't need us. At some point in the future, if you do, we'll be here, right? And so you build that connection, you build that relationship. So it's kind of like providing value first. But a lot of attorneys don't like that concept. They're really sort of up in the arms about this. Oh, legal paraprofessionals, they're going to come undercut us on price, and they're going to come do this, and they're going to shake the apple cart, and it's not going to be good. And I'm thinking, well, I've already been giving away free information. I'm putting together a course right now based on my book, Beginning to Winning, right? So I've got a whole 9-step framework that I basically, it's for free. If you want it, you can get it on our locals channel. I'm trying to give information out so people can know how to process some of this stuff themselves rather than having to hire an attorney to do it. Now, there are many situations where you absolutely have to have an attorney. In fact, I would recommend it in almost every case, but I just know that most people can't do that. They just can't afford it. And so I'm not going to leave them out to dry if I can help it. They can get a copy of my book. It's free PDF over on locals. I'm going to put together a course based on the book right now that I'm working on. And so that's going to be coming out hopefully this quarter. And we're probably going to give that away for free too, right? We want to help as many people as we can. So we're already operating in that space. The legal paraprofessionals, I don't have any problems with that at all. I mean, if they do a good job, as long as clients aren't getting underserved, if more people are getting better results, if more people have access to good representation, I don't care who does it. So good question though, OSOC. We have No Doubt says, please share your thoughts on punishment modifiers for how gang membership and hate crimes. I think I answered that question, no? Yeah, I think I answered that one. We have Jack Elias says, I maintain that only incitement to insurrection is the malice and anti-American agenda of the left. Yeah. Good point there, Jack Elia. We have Jeremy Matrita says, how can the president be charged with inciting an insurrection if the claimed insurrection failed? Shouldn't the claim be inciting an attempted insurrection? I think you could... I think you could make that argument, right? I mean, the insurrection was not successful at all. Like they were basically out of the building and they were back to work within 4 hours or so. So yeah, it was an attempted insurrection. Still would be a misdemeanor. So I still think they can move it forward. So kind of splitting hairs on that, but I understand your point. It was not a successful insurrection. The follow-up question would be, okay, well, if it was a successful insurrection, then they wouldn't be prosecuted. Right, because they would be in control of the government and presumably the Department of Justice, so they wouldn't be prosecuting themselves for seizing control of the government. We have See the Veil says, can impeachment be used against Biden on the following? Opening the border with no due inspection upon immigrants, per Biden's orders. 2, knowing the cartels plan to invade the USA with drugs, sex slaves who are minors, and rape trees being the evidence. I've not heard of a rape tree. Knowing they run guns of various makes into the USA. Does this not qualify as disruption of government and threatening the lives of Americans as national security? Maybe I'm off the mark. I mean, look, you could... My opinion is the answer is no, right? I mean, I don't think Trump should be impeached under this standard. I don't think that Biden should be impeached. I've drafted articles for Kamala and Chuck because it's a joke. It's ridiculous. The standard is so low that it's basically encompasses virtually anything. By their own words. I'm not making it up, okay? I'm not trying to be ridiculous just for the sake of being ridiculous. They wrote it, and we're just taking their standards and applying it. So could you make the argument against Biden? Yeah, you could. I don't even think you have to go that far. You just find a situation where Biden said something, and somebody did something bad as a result of it, or the government was interfered with as a result of it. And yeah, it's the same standard. Don't even have to prove anything. Well, we'll see what they unveil tomorrow. But yeah, in this case, generally the answer is no, right? It's not impeachable. These are just policy decisions. You shouldn't be impeaching people for policy decisions. You shouldn't be impeaching people for making political statements, for arguing over legitimate political issues. If you're upset about an election that you think was stolen from you, are you not supposed to talk about it? You just want him to go, oh, well, this election was stolen, but I can't talk about it because that might incite insurrection. So therefore, I'm just going to sit on my hands along with 70 other million Americans who also have some questions about the regularity of the election. And we're not going to talk about it because we can't. Okay, you have to talk about those things. Now, you can disagree with how he talked about them, but you got to talk about them. And if every single political statement that you make that's challenging anything is now incitement of something, that's a bizarre country to live in. It's certainly not something that is conducive to progress and democracy. We have Jack Elias says, has there been any scientific studies to demonstrate that more or less justice is achieved through mandatory sentencing? Good question, Jack Elias. I don't know the answer to that. I would think that just sort of off the top of my head that the answer is probably no. It probably does vary from jurisdiction to jurisdiction. So I'm not sure how well a study would be responsive to that. But, some like in Arizona, for example, if you get a DUI and you're convicted, you go to jail. It's in the law. California, no, right? Your first offense, you don't have to go to jail. You go to probation, take some alcohol classes, and you're good to go. So, Arizona has mandatory version of DUI sentencing. California doesn't so much. And so, you've got two hugely different populations with different penalties. And so to have a study that identifies one way or the other, I don't know. I will tell you this, though. People still commit DUIs. People still are using drugs, right? You can punish the hell out of people. People are still going to break the law. So I'm not sure that increasing punishment is always the answer. And that has been the trend in our criminal justice laws and rules for a long time, 30 years, really. I mean, we're just started last year as a result of George Floyd, Breonna Taylor. People are now starting to go, hey, maybe we should rethink some of this stuff. But up until that time, it's just been the same thing. Harsher laws, more severity, because the politicians don't know what to talk about. They don't know how to talk about anything else. They just defer to what they're pre-programmed to say. Oh, tough on crime. I'm tough on crime. The police unions love me. The police love me. The firefighters love me. Hey, look at this. So the penalties get harsher and there is no justice. Hack Consulting says, I argue that we need peace in order for justice to become abundant. But then again, how can we have peace if we have no principles to coexist on? It's a deep question there, Hack. So I think this is a point that guys like Ben Shapiro make all the time. Politics is downstream of culture, right? You got to have culture before you're going to have a functioning political system. Now, I don't necessarily agree with that. Culture, I think, is very important. And I sort of believe in the Edmund Burke concept of a social fabric, and we all have to have certain ideals, and we all got to think a certain way. I mean, not think a certain way, but I would say be invested in certain fundamental principles, right? If you are a democratic republic, and you have half the country that doesn't believe in that stuff, well, you're not going to be functioning very well as a democratic republic. It's not going to work out for you too well. So you got to have some alignment in certain areas. And it does maybe feel like that's diverging apart a little bit more now than it has previous years in my life. Chris Wiseman says, how do you feel about 3 strikes or mandatory sentencing for small class of violent felonies, rape, murder, kidnapping, or is it just too slippery of a slope? Also, Marsh versus Alabama, check your tips box. Sent an analysis a while ago. All right, so Chris is on it. Chris, what a guy. Thank you for that, Chris. I will take a look at that. Faith, don't write that down. All right, because Chris already sent it. All right, so how do I feel about 3 strikes or mandatory sentencing for small class of violent felonies? So yeah, most of those, you don't need 3 strikes for those, right? If you're convicted of rape, I mean, it's just automatically a very high threshold, which I think is justified, right? I mean, if they can prove their case. And the rape cases are not as cut and dry as many people think. There's a lot that goes into those cases. But that being said, the crimes against children, murder, kidnapping, those types of things. Yeah, the penalty, you don't need 3 strikes for those. You get 1 strike. That's it. 1 strike, you're out. The penalties are so severe. Child pornography, it's like 10 years of photo in many places. You got 5 photos, 50 years. That's it, right? That's it. So it's, I think those are more justified. The problems, my bigger issues with the 3 strikes rules are, alcohol crimes and drug crimes. Those people are addicted. They're not bad people. They've got an addiction problem. Throwing them in prison for 2.5 years is not going to solve that. It's going to make it worse. There are plenty of drugs in prison. When they get out, they're going to be a bigger detriment to society. They're going to be harmful to themselves. It's not good. So that's kind of where I would divest or diverge. Certain classes of crimes I think should absolutely not be 3 strikes. We should have other punishment, quote, measures that are focused more on rehabilitation and restoration rather than pain and punishment. We have Cattle Caregiver says, if the scenario about Trump being impeached and then appealing to the Supreme Court happened and the Supreme Court overturned the impeachment, would mean a lot of things have changed since the Texas, mainly Roberts. So I think you're talking about the Texas lawsuit. Yeah, I think that the reason the Supreme Court did not want to get involved in the underlying election litigation is because it was really kind of a political question as far as they could tell. When courts are asked to weigh in on political issues, they really like to punt those cases. They say, well, it's a political question. Go deal with that in Congress. Go deal with that at the ballot box. That's not our role. And Judge Roberts is somebody who wants to be very, very cautious and cognizant of the court's reputation. He does not want to get out there and jeopardize the court's credibility, because if the court's credibility is jeopardized, they lose their legitimacy, and the court's legitimacy is the only real source of their power. So it's sort of, he protects that at all costs, to his credit. And I got a lot of disagreements with John Roberts, but I think that he is a brilliant man, and he has the sanctity of the court first and foremost, even if I disagree with that. So I appreciate his duty to that, but it would be different. The Texas election lawsuit is one that was highly political. This one would also be highly political if Trump was trying to overturn his impeachment conviction, but it's addressing a constitutional issue of law that I think is a matter of first impression that the court has not already ruled on. So they might be more inclined to hear it. I don't think it's a likely scenario. I think Trump just doesn't get convicted, period. We have another one from Jen McClellan, says, what's up, Robert, Faith, Joy, Ma, Fox, and all the rest of you? I work from home and rarely speak to coworkers. I choose your outlet to learn about the law and have some water cooler time. Thanks, chosen coworkers. Brilliant peeps. Thanks, Jen McClellan. That's a very nice comment. We're glad that you're here, and we're glad that you're hanging out with us, because I think this is a good spot to have good conversation. I learn a lot. I mean, literally these questions get me thinking. Obviously people like Chris are just throwing out knowledge in front of all of us. So it's kind of a cool thing that has developed, and I'm very grateful for all of you for making it a reality. And our last one of the day is from Hack Consulting. Says, people who are, quote, tough on crime should not be solving the crime issue. Give us better policies and enforcement methods instead of planning to throw the book at every druggie that gets arrested just because they, quote, broke the law. Hear, hear, Hack Consulting. I think we have a lot of politicians who don't know anything about criminal justice, and they're all just pontificating. They're all doing what sounds good. And, a lot of people in this country, unfortunately, they sort of like to make themselves feel good by watching how bad other people are. A lot of people live in judgment. A lot of people are just kind of walking around the world going, oh God, look at her hair. Look at her shorts. Look at that car. What an idiot. Why is he doing that? Right? All the time. Their minds are just sort of spiraling that way. And so when they see articles about somebody got arrested, or they like to go on the Mugshots website and go, oh God, look at these dregs of society. What a bunch of disgusting people. Then that's just something that makes them feel better about themselves. And so you have politicians who are always out there criminalizing, talking about how awful certain people are, and other people go, yeah, my life's pretty miserable, but at least I'm not that guy. At least I'm not that person. And so they just get on board. And I can't tell you how many people I've talked to say, I've never broken the law. And I go, yeah, you have. You just broke the law right here. I watched you do that, and that's a crime, and that's a crime. And we drove in your car. That's a crime, right? And, people just like to have these sort of differences as it relates to justice. And my only position on this is, look, there are a lot of good people who are in that situation. Just because you have not been in that situation doesn't mean that you will never be in that situation. And if you are, I do hope that you have good representation and you get through it okay, because many people do not. And I want people to be treated well, treated with justice, and ideally come out the other side better off. Looks like we got a couple more that came in late. We have Jack Elias says, Robert, do courts still offer disulfiram to alcoholics, or do they assign it for the year necessary for the person to begin real adjustment? I had a family friend commit suicide over alcoholism. Sorry to hear that. At the end of a 3-month period on disulfiram because he didn't manage to get free of it. So I don't know what disulfiram is. If you're thinking about what's it called? Antabuse is what I'm thinking of. Is that the generic name for that? Antabuse, Antabuse, one of those drugs. No, I haven't seen that in Arizona. If it's the same drug that I think he's talking about, there is a drug that you take that makes you violently ill if you consume alcohol. Basically, even if you have like hand sanitizer on, if you ingest alcohol through your body, through pores, if you drink it, you can become violently ill. I've never taken it or tried it, but I've heard of other people who have, and it's not a good experience. And so the idea is you take that so that if you do drink, you sort of disconnect, you disassociate yourself from the good feeling of alcohol. You're sort of like Pavlov's dogs, right? Every time the bell rings, you start salivating for the food. Well, if you take this particular drug, you get that same craving for alcohol, but you ingest it, now you get physically violently ill. So the bell's ringing, but you're not salivating, you're thinking of vomiting, and so the alcohol suddenly doesn't feel as attractive to you. And so, I'm not sure specifically what you're referencing there, Jackalai. I've not seen that in my practice, but doesn't mean that those types of deals aren't being negotiated. Another one from OSOC. Rob, does the 3-strike rule have to be the exact same crime to apply in Arizona? No. So it can be a number of different felonies. So let's say, for example, you have a aggravated DUI, right? It's your 3rd DUI. You got an alcohol problem. Boom, you get a felony conviction for alcohol. Strike 1. Now you come back, you got a drug problem. Well, it's a felony drug problem. Strike 2. You get another felony drug problem. That's strike 3. Now you're going to prison for, a decade probably, depending on what your charges are. So it doesn't have to be the same charge. You could have multiple different charges as long as they're different dates of offense and they're all felonies. It's just going to move you forward in that sentencing chart. Jason Segal says, couldn't a legitimate charge of negligence be brought against the individuals who failed to order a substantial number of police to protect the Capitol on January 6th? The potential for trouble was known in advance. And what about the charges against the police themselves for letting the, quote, mob into the building? Yeah, Jason, and that's sort of why I put negligence in there on the flow chart, right? I think that that's a pretty pertinent question to be asking right now. Now, I don't know what the answer is because I don't think we've seen any investigations from the people who are responsible for the security that day. My understanding is the Capitol Hill police are still investigating. I think the FBI is still investigating. I would like to hear from the Sergeant of Arms for both the House and the Senate. I would like to hear from the former chief of police for the Capitol Hill police who resigned, Stephen Sund. He's out there. And there's a lot of information here, right? But we're asking the government to investigate themselves. And I'm not particularly optimistic that they are going to give us what we're asking for. So we'll see where that goes. And that was the last question of the day. So want to remind you that we have sort of transitioned our home base over to locals.com. And it's a great platform because we have a lot of good stuff that I'm going to tell you about over there. But we're sort of doing this soft disconnect from some of the mainstream platforms that have less freedom for us to come out here and speak our mind. As we know, we're seeing sort of the narrowing of commentary from around the internet, not just on this channel, but other channels as well. And so Locals is kind of one of those experiments where we're trying to get some people to join a new platform, one that has a strong dedication to free speech. And it's also giving us a little bit of freedom. If we don't have to worry about monetization and demonetization or worry about certain chat platforms canceling us or terminating us, temporarily banning us of these different platforms, if we can operate in a safe zone, then that's pretty cool. We can actually even have more free conversations and maybe talk about some things that might be too provocative on some of the more mainstream channels. And that's what we're doing over at Locals. So I want to invite you to go on over there. It's watchingthewatchers.locals.com. We are going to be posting the slides over there. And I want to thank the people who are supporting us there because without you, it would not be possible, right? We are sort of asking you to help us build this different pillar. And these people are helping. So let's take a look. We've got Jason Segal, saw him today. Sarah Smothers was also chiming in. We have Hain 202, Cody Bear 1. We got Sliding Edge, Ma Fox as always, and Faith Joy. Thank you for your help. We had a lot of new people sign up. So we had yesterday, Cats 59 was already subscribed. Danny Girl. We have Angly. We got One Drop. And then we had some newbies join in. We got we saw XN Drew today. What's up, XN Drew? Okay. So who joined? Got a lot of people. S-Dog 322, the _ Mariner. We got Kavor. We got Barbie Ann. We've got Doragos. We have Hot Dog Fixer. Lana 12. B Campy in the house. Matt Maker Jenny joined up. We got Schnookums. Good to see you, Schnookums. We got J Proper. We have Echo House. We have Dark Hour 1992. Abby Lou Jack. We have I'm a Lemon. We got Mother Joe who joined up. I think I might know who that is. We have Yulia Bellaris. We got Larry 1944. We got D Nice. Lou Walker. See the Veil joined up. Saw him around here today. We got Get Some Skates. We got Katie's. We got Bernadette C. We have Woodworking Medic in the house. We got Kenny B1B. We have RR Law Group in the house. Oh my goodness, RR Law Group. I don't think that's actually the RR Law Group, but somebody snagged a good username. We have SF Bob, must be from San Francisco. We got No Doubt in the house. I love them growing up. We have Joe's Now, Blake Brown. We got Dangerous Freedom. We got 111 Patriot in the house. And then we got Mad Max 07. And lastly, but not leastly, Fish Are Friends. And I don't have a good fish tank right now, but I used to have a beautiful fish tank. It's a lot of maintenance. Now it's over at Eric's house, which is it's a good little nonprofit organization. So I want to thank everybody for your support over on Locals. What's going on over there? Well, if you want to head over there to watchingthewatchers.locals.com, you can get a copy of all this stuff. Of course, my free book is over there, Beginning to Winning. I talked a little bit about that today. You can download a PDF if you'd like. You can also get a copy of the slides, which are available for download. Get a copy of the impeachment documents. We're not going to keep talking about the impeachment, of course, after the impeachment. So we're going to get rid of that as soon as the impeachment party is over and replace it with something else, I'm sure. But get a copy while it's hot. You can also get a copy of the Existence Systems, which is a little personal productivity tool that I use. I made a video on January 4th. You can take a look at that. Share links and conversation over there. But the main reason, of course, is great people. A lot of awesome people over there. And we want you to be there. So go check it out. Watchingthewatchers.locals.com. One other reminder to subscribe if you're not already subscribed here. We go live at this time every day of the week, every weekday. We want you to be a part of that. Lastly, but not leastly, I am a criminal defense attorney here at the R&R Law Group. We're in Scottsdale. We help good people charged with crimes find safety, clarity, and hope in their cases and in their futures. We love to help good people. We help with current, open, active criminal cases anywhere in the state of Arizona. We also help with old closed cases. We can clear a record up so you can restore your right to vote, restore your right to possess a firearm, become a full citizen again. We help with mugshot removals. We can clear up old warrants. We do a lot of stuff. We're pretty good at it. We're pretty passionate about it. So if you happen to know anybody who needed help in any one of those areas, give our office a call. We offer free case evaluations. We would love to speak with you or the people that you know. Make sure that you leave in a better position than when you contacted us. So that's it for me, my friends. I want to thank everybody once again for being here, joining us as this impeachment party goes on. Everybody have a wonderful night. Sleep very well. I will see you tomorrow, same time, same place. Back here, 5 p.m. Arizona time, which is 5 p.m. Mountain, 4 p.m. in California on the West Coast, 6 p.m. Central Texas time, 7 p.m. for those of you on the East Coast, and for that Florida man. Everybody sleep well. Have a wonderful evening. See you right back here tomorrow. Bye-bye.